ডিমেনশনের পরে ডিমেনশনের পরে আর একটা ফিক্স ম্যাটার আছে, সেকেন্ড অ্যাপিল। আর ওটা আছে, তার আগেও একটা আছে ফিক্স ম্যাটার বলে, এই যে হিয়ারিং ফিক্স 29, ঠিক আছে? ডিমেনশনের পরেই এটা 63, তারপরে 29।
May I have may I have my lord's leave to mention a matter? But before that, my lord, I'm wishing my lord a very happy and prosperous
Thank you.
English
Same to you.
My lord, I am here not for mentioning. I have already mentioned this matter. This is pertaining to our order in a contempt jurisdiction passed by my lord Justice Mantha and your lordship. Now, my lord, we have taken out an application on behalf of the CBI, because CBI officers were the contemners, for modification of that order, because the order has already been complied with. Now, my lord, the Honorable Justice Mantha is of opinion that my lord, Justice Mantha may sit with your lordship on Friday, this Friday, my lord.
Yes.
And he has asked me to ask for your convenience so that we can intimate, if my lord, it is convenient for my lord to sit down with Justice Mantha in the division bench for consideration of our application, because personal appearance has been.
If his lordship does not have any
No,
inconvenience,
my lord does not have any inconvenience, because in the morning I mentioned, my lord said that I should come and inform my lord and ask my lord whether my lord has any inconvenience.
anyway, I can take you. I can
My
sit
lord,
with
then
his
I will-
lordship on Friday.
Yes, my lord. Then I will inform
at 2
the
PM or something like that.
my lord. I shall. I'm great.
Two
Application for?
application for condonation of
Yes, give the slip.
My lord, may I be
The application was very urgent matter. My lord, the execution has been fixed on 9th Friday, my lord. The file is here.
Application for stay.
Stay, my lord. Execution file, my lord, tomorrow, my lord, matter, my lord, other, my lord.
The records are here. It will
Yes, my
appear
lord. Yes, my
tomorrow.
lord. File is here, my lord.
may I be permitted to mention, my lord,
tomorrow,
one
my lord.
matter which
Yes,
is
if the records are here, ওটা দেখে নেবেন,
Record
রেকর্ড থাকলে
here.
দিয়ে দেবেন কালকে।
one matter, my lord, which is due to appear today, but it is not in the list.
No, under what heading?
My lord, application.
Application for?
Call, my lord, filing report of the special officer.
Okay,
You'll kindly see your lordship appointed a special officer, Mr. Manoj Sadhu.
let
My
me
lord,
see. Anyway, it will appear as to be mentioned.
Yes,
Okay, if the record is here, it will appear as to be mentioned.
my lord, it will appear tomorrow, my lord, because my lord.
If the records
Yes,
are here, it will appear
record is
tomorrow.
here, my lord. Because my lord, Mr. Sadhu
Mentions me.
requested me that he has some difficulty.
No, is the report ready?
Yes, he said the report is ready.
Anyway, let it appear tomorrow as to be mentioned.
Which is which?
Yes? Contempt application in which matter? Regarding violation of whose order? When was the order passed? Yes.
Lordship, may I,
Yes.
Contempt application, my lord.
Lordship, may I permit you to mention one matter, second appeal hearing, Lordship. In the month of November, I, Lordship, mentioned this matter, and
Second appeal hearing wait this week. Okay,
Lordship-
hearing matter wait this week.
Lordship, one thing, Lordship.
Yes.
In the month of November, I mentioned this matter. Lordship was allowed this matter and directed. to
Now for
December.
this week, please wait. I'm not including hearing this week. Try next week.
Already filed lying in your Lordship's.
Whatever it is, you try may mention next week. I shall consider.
May I be permitted to mention for inclusion arising out of a claims compensation case, two applications, one condonation of delay is there.
Yes, give it.
My lord, this is original.
Just a minute, please.
May I be permitted to mention which one of first appeal relating to one MSCC case, my lord, arising out of the MSCC case. My lord, it was directed by the Honorable Justice Aruna Bandhavata the matter to appear on 26.
No, is it a part heard matter before our ladyship?
Matter, my lord, it is hard.
It is a matter, hearing matter. Okay, just wait this week. Next week, try next week.
My lord,
Yes, original side matter. Yes, anything?
One of the writing out of MSCC for inclusion.
No, inclusion for what? Hearing or application? Hearing next week.
Also, may I permit to mention for one stay applications for inclusion.
Stay application MSCC. Yes. Yes, original side mentioning.
yes, my lord. Kindly acknowledge.
It's for drawing up and completing the order. Yes.
Grateful, my lord. I am deeply apologize for any inconvenience caused to court from my.
Anyway.
Grateful, my lord.
No. Drawing up and completing order passed by this court.
Yes, my lord.
এইটা
Yes, my lord.
এইটা ড্রয়িং আপ এন্ড কমপ্লিটিং 28/11 এর অর্ডারটা ড্র আপ এন্ড কমপ্লিটের জন্য বলেছে, দিয়ে দিন ওটা।
আমি অ্যাটাচ করে দিয়েছি, my
ড্র
lord.
আপ এন্ড কমপ্লিটের ওই অর্ডার।
Grateful, my lord.
Item number 5.
But in this matter, I am on behalf of the appellant, my lord. As per direction of your lordship, my lord, I have served the copy. This is the affidavit of service.
Oh, this is what claim case?
Claim case,
I am for the respondent insurance company.
You are for the appellant.
my lord.
I am not received the.
No, question is what? Any application is to be taken up?
My lord, let the matter be fixed for an hearing and the paperwork has already been filed. Matter is ready for hearing.
Paper books are ready.
Paper-
So your learned friend has not received the copy.
My lord, this is my change brief and the paperwork has already been filed in the department, my lord.
No, please serve your learned friend a paper book.
My lord, kindly pass a direction.
Yes, record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books have been filed, let this matter appear for hearing on 14/1/2026. The paper books, copy of the paper book be served upon learned advocate for the respondent insurance company.
My lord.
Your lordship directive, court officer, my lord, to give me a copy.
My lord, already 8 copies has
Yeah,
been filed,
okay.
my lord.
A learned advocate may collect the copy of the paper book which is already filed.
My lord, deeply obliged, my lord.
Hard copy to. Follow one, 10 copy, 7 copy, এক copy please.
Item number 6.
Yes, item 6.
My lord, it is passed by the Lok Adalat and the file is reconstructed. An order be passed by the Lok Adalat. The order is there.
Disposed by the local law.
Yes, my lord.
So it is appearing for what heading?
I am appearing for appellant. This is the order for check revalidation.
Okay. No, the question is,
My lord, last occasion, your lordship
yes.
desired to, my lord, ask the LMO registered administration
yes,
to, my lord, make reconstruction of the file and, my lord, file be sent to the local for disposal.
yes.
And local, my lord,
Pass this order.
pass your lordship kindly see the.
No, this is the order dated the 13th December 2025,
The last
where the
local-
insurance company was directed to issue fresh check and to take back the old one.
Yes.
That is the direction issued. So you,
So no order need be passed.
yes, record an order. As learned advocates for the parties are present, as necessary orders is passed by the learned Lok Adalat on 13th December 2025. No further order is required to be passed. Let the matter go out of the list.
My lord, only thing, my lord, your lordship may pass, let the learned register general be expedite the matter.
Learned Registrar General is requested to expedite the matter in terms of the order passed by the learned Lok Adalat.
I'm getting.
Seven, my lord, I am acting on behalf of the appellant, my lord. All formalities has been completed. Mr. Homik is appearing on behalf of the respondent insurance company, my lord. Paper book has been filed, my lord, earlier occasion.
Yes, record an order.
Yeah.
Yes, you are appearing for?
I'll fix it.
You are for the insurance company. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books have been filed, let this matter appear on 15/1/2026 for hearing. Yes?
After 3 weeks.
3 weeks. 28/1/2026 for hearing.
28.
স্যারের নামটাও লিখে দাও এসকে ভূমি correspondent insurance company.
I am for the respondent insurance.
In this matter, I am for appellant, my lord. All are ready, my lord. Kindly fixed a date for hearing.
Yes,
appeal
record
hearing.
an order. Learned advocates for the
Paper book
parties are
filed.
present. As the appeal is ready for hearing and paper books filed. Let this matter appear for hearing on 15/1/2026.
16th, Lordship.
Okay, 16/1/2026.
Oh.
Milord, I am appearing on behalf of the appellant. I am praying for not today, Milord, as a learned advocate, Mr. Supratik Shamol, not come to the court due to sudden illness.
Okay, not today.
My lord, one more indulgence, item number 18, same order.
18 also.
18 also.
Okay.
The
This is an
appellant.
application. 18, but both of you are appearing in both the matters.
Both the matter he will appearing.
Well, I am appearing on behalf of the.
No, in 18 also you are appearing.
No, no.
No, my lord.
So the other side advocate is not
Item
here.
number 9, my lord.
Let this be called on. Okay.
No,
Okay.
not today and not tomorrow, my lord.
Okay. Item?
Item 9, my lord.
Okay. Item 9, not this week.
Not this week.
10 is my appeal, my lord. Lordship, this matter came up before Lordship on 8th December 2025.
It is for correction.
It is for correction, my lord.
Yes, let me see.
Inadvertently, it was directed the matter to appear on 6th December
Yes, let me see.
instead of 6th January. Lordship was kind enough to extend the interim order till 16th January.
Ajay. Ajay. The matter is put up for necessary rectification of order dated 8/12/2025. In order dated 8/12/2025, there was a direction to list this matter on 6/12/2025. However, this order stands rectified and modified, and the matter be listed on 13/1/2026.
Because the interim order is still 16th.
13/1/2026.
13/1/25.
You intimate the other side advocate.
I'll intimate the other side. I'm much obliged, my lord.
Item 11, I'm preparing short pause for a minute. Mr. Amit Rai is not.
Talk with Mr. Rai, Amit Ranjan Rai, Lordship. We have received for the respondent insurance company. We have received the paper book, Lordship. Kindly fix up a date for hearing. I had a talk with him.
I'm just making it not today or.
Yes, my lord. Yes, it's coming, my lord.
He's on the way. I had a talk with him.
Okay, record an order. Learned advocates for the parties are present. As the matter is ready for hearing and paper books filed,
Kindly keeps the matter on 16th. I had a talk
let
with
this
him.
matter appear on 16th. 16th is Friday, so let it be either
15th. I have got another matter fixed.
14th. You have any difficulty?
14th আছে দাদা কিছু?
Huh?
14th কিছু আছে দাদা?
Huh?
No.
Achha, let this matter appear on 16/1/2026.
That is why I'm
Okay.
playing short pause for a minute. He has talked, but
16/1.
Date for.
Told him 16th.
Yes.
He told me.
থাকতো।
মাছ হবে। কথা হয়ে গেছে।
16
16 তারিখ।
না সেটা ঠিকই আছে। ওই 16টার আপনার
না না।
ঠিক আছে। All right, my lord.
Yes, item 12. Okay, not today.
Well, item 13, my lord, it is a revisional application ready for hearing, my lord. Kindly fixes up any date.
You are for?
I'm for the opposite party, Your Lordship. Matter was heard, partially heard.
My lord, I has made substantial
Part
submissions.
had matter.
Yes.
Yes, Your Lordship.
And kindly marks it, part had, my lord, takes it up any day next week.
Fixes a time, Your Lordship. That would be easy for both the parties.
And my lord kindly extends the interim order. It is expiring on 14th, my lord.
Yes, record an order. Order ছিল কি নাকি অ্যাসাইন ছিল ম্যাটারটা মানে কোন অর্ডারে এটাকে পার্ট আউট করা হয়েছে
No, my lord, it has not been marked as part had.
ও দেন হাউ দিস ম্যাটার
This is
It's an
specially
assigned
assigned.
matter. আচ্ছা আচ্ছা দেখুন তো ওই 13 তারিখ বা 14 তারিখে কোনো ইয়ে আছে কিনা ফিক্স ম্যাটার কোনো ফিক্স ম্যাটার আছে কিনা দুটোর সময় কি তিনটের সময় না না এই সেকেন্ড অ্যাপিল রিভিশন এগুলো কি জন্য ফিক্স এমএসসি কেস ফিক্সড
12 তো ছুটি।
তো 13 or 14
Any day convenient to lordship.
14th would be.
14th would be. 14th one.
14 তারিখে 3টের সময়, 2টোর সময় আছে, 2টো ফিক্স আছে। 15 তারিখে দেখুন। না ফিক্স টাইমিংস আছে কিনা, 2 PM আছে 15 তারিখে। সতেরো তারিখ শনিবার, হ্যাঁ 18, 19। Okay, let this matter appear on 18/1/2026. Sorry, 19/1.
My lord, 19, I have some difficulty, my lord.
Okay, 20th January 2026 at 2 PM.
My lord, and the interim order be extended, my lord. It's
The
still
interim
14.
order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Obvious. 20 তারিখ 2টোর সময়, তাই তো? Obliged. হ্যাঁ।
So this matter, I am appearing for the appellant. A very old matter, Your Lordship, kindly fix any day, Your Lordship. Other side has been served, a copy have been served, everything is ready.
Okay. Yes, record an order. Learned advocate for the appellant is present.
So I'm
For the
filing the
appellant,
paper. I'm filing the copy.
let the paper books file be kept with the record and a copy be served.
Copy have already been served, Your Lordship.
Copy be served. If not served,
Your Lordship.
let this matter appear on 15/1/2026.
16th,
15/1/2026.
15th. Lordship, this is very old matter, Your Lordship.
Okay, there are other matters fixed.
Practically, your owner have been directed to pay the compensation
Anyway,
amount, Your Lordship.
15th is not just 1 week after. 15/1/2026 under for hearing.
Diploma.
15, my lord, I am appearing on behalf of the appellant, my lord. Mr. Pahar is appearing on behalf of the respondent insurance company. All formalities has been completed, my lord.
Item 15, let this learned advocates for the parties are present. As the appeal is ready for hearing and paper books filed, let this matter be listed for hearing on 15/1/2026.
Next week.
Yes?
এটা পেছনে আসবে এটা
Let it
25
appear on 15/1/2026.
my lord, yes. হ্যাঁ পাহাড়ি স্যারেরটা দিয়ে দাও না।
Okay, not today. Okay. 16. কি আছে দেখ? বলতে 24, 25 রেকটিফাইড হয়েছে আগে, হ্যাঁ? Yes. Oh, is disposed of. Year of is disposed of. 2024 is disposed. ওটা 25 হবে। Yes, the matter is put up for necessary rectification in order dated 17/9/2025. Stop. In order dated 17/9/2025, last paragraph, it is observed that revisional application being CRR 3053 of 2024 is disposed. However, it should be rectified and corrected as CRR 3053 of 2025. Stop. Other contents of the order remain unaltered.
তুমি কতক্ষণ চালাবে? কলারটা উঠে এইদিকে একটু। কলার উঁচু রেখেছে। মোটামুটি চলবে তো কিছুক্ষণ এখন?
তো চলবেই। আমি বলবো তারপরে ওনারা বলবেন তারপরে। I'm appearing on behalf of the appellant insurance company, my lord.
I'm appearing on behalf of respondent number 2, my lord.
This matter was taken up earlier and I had started my arguments, my lord. Sorry. The paper book Thank you. The paper books are already on record, my lord. 2 sets of paper books I've already submitted, my learned friends.
ওই যে ওই যে ওই যে ওই যে।
No, no, বেশিক্ষণ চালাবো না। My lord remembers, my lord, I have preferred the appeal, my lord. The first ground being non-involvement.
Yes.
Yes. First information report, my lord, it was lodged against vehicle number A, bus number WB336350. Thereafter, it was changed to vehicle number B by the same FIR maker, that is WB33A 2950.
Yes.
The accident, my lord, it took place between a Toto and a bus. And the victim, he was
The delay in regarding lodging the complaint, delay
it was lodged on the very next day
on the following
against
day.
following day. Accident, my lord, it took place on 27th of August 2019. 27th August 2019. And written complaint, my lord, it was lodged by the Toto driver on the very next day, that is on 28th of August 2019, against a vehicle bearing number WB336350. Thereafter, my lord, on 17th of October 2019, the same Toto driver or the FIR maker, he filed one notarial affidavit and changed the number. It was not even an affidavit affirmed from the court of the learned first class magistrate. It was just a notarial document, my lord. And the number was changed from 6350 to 2950. Sorry. Almost 1.5 months after the accident. And after that, my lord, on 18th of October, this vehicle B, that is 2950, it was seized. And thereafter, everything is
On the basis of subsequent complaint.
subsequent complaint.
Subsequent version.
Yes, yes. And the interesting part is, my lord, the owner, he appeared before the court of this first Chief Judicial Magistrate,
Offending vehicle.
owner of the alleged offending vehicle, that is the subsequent 2950. He appeared before the criminal court, my lord, and he obtained bail.
Owner means the driver come owner.
Driver come owner. But he chose not to appear before the learned tribunal. He filed his written complaint, and thereafter it was this award, it was passed ex parte against the said owner.
So vehicle owner did not appear before the
Tribunal, my lord. And after this 17th, that is the second affidavit. After 17th, everything falls on place. Everything is fine. Vehicle is seized, and thereafter the normal procedure follows. No doubt, it's an unfortunate case. It's an injury case, my lord. But insurance company also should not be penalized, my lord, for no fault on its part. I've already made some, my lord remembers, I've already made submissions in this regard, my lord. Today I won't be taking much time. I'll just go through the pages once. Do I need to go through the pages once more, my lord? My lord will kindly come to the first FIR, page 55. Sorry. খুব অবস্থা খারাপ। আপনি মাথার উপরে বসে আছেন। কালকে জ্বর ছিল। My lord will kindly come to page 55. Page 54, this first information report, my lord, it starts.
So entire contents of the complaint same, only the number is changed.
Yes, yes, and that too, we did this notarial.
After how many days?
Almost more than 1.5 months. Accident is on 27th of August, and this affidavit, it was filed on, my lord, 17th of October.
That means after 1 month.
Yes, more than 1 month. August, October, more than 1.5 months. And the vehicle, it was willingly produced by the owner before the police, my lord, after receiving notice. And in the award, my lord, issue number 2, it has been framed, my lord, regarding this involvement, whether the vehicle was involved or not. Sorry. And it's even more surprising, my lord, that there is no independent eyewitness to this accident.
How many witnesses were examined?
3, 4, 5 witnesses were examined.
From the claimant side.
Claimant side. Claimant side, 5 witnesses were examined. PW1 is the victim, and the other witnesses, PW2, 3, 4, and 5, they are in connection with her treatment and her employment, my lord. But no independent eyewitness was examined, and the FIR maker was not examined. And I'm purely on facts, my lord. The facts suggest that this second vehicle, that is 2950, my lord, it was implanted. Because it's a hit and run case. And probably that or it's either a hit and run case, or probably the first vehicle, the papers were not correct, my lord. So this second vehicle, my lord, subsequently this was implanted. And owner had initially appeared, filed written statement, my lord will find that at page, my lord, 31 of my small short paper book.
Page
31.
Yes.
My lord, second paragraph. Initially, the OP owner turned up to contest the case by filing written statements, but ultimately this OP did not contest the case. Hence, the proceeding is therefore heard ex parte against the OP owners. So the owner chose not to appear.
And definitely the FIR maker must be a witness in the criminal case. Has to be a witness.
Maybe no, I do not know. My lord, I don't have the
Charge sheet.
No, I don't have the
list of witnesses.
Yes,
Charge sheet
yes.
list of witnesses.
I'll come to that.
He has to be a witness.
Maybe. I'll just check. Yes, he is there, number 1. But then charge sheet, my lord, it's all after 17th of October. That is the
usual procedure.
my
The
lord.
fireman
Usual,
has to be a witness.
yes. Usual procedure was followed after 17th of October, my lord. The usual procedure was followed. Everything it falls in place. There is no dispute after that. This is my first ground. Now, regarding this ground, my lord, I've taken two more grounds, my lord. One is regarding a permit of this second vehicle. It was neither seized nor produced before the court, so I've taken a ground that it was not valid on the date of accident, my lord. So maybe I may be granted the right to recover the compensation from the owner of the vehicle, my lord. And I have also taken the ground that this future prospect, my lord, it should be 40%. 50% was granted.
So 40% future prospect should be there.
Should be granted. If the involvement of my vehicle is admitted.
Government service.
No, my lord. She was working. It's a private service. She was in private service. And
considering the age, 40% should be future prospect.
My lord. She was 37 years. Victim was 37, aged about 37. And another ground I have taken, my lord, this non-pecuniary damages, 5,50,000 has been granted, but I leave that to my lord because
5,50,000 under what heading?
different non-pecuniary heads, my lord, as
Pain
in
and suffering.
pain and suffering, inability of injured to earn, etc., etc. That I leave to my lord because it's 85% disability and it's an amputation case. So I leave that to my lord. And the last other two grounds, my lord, being interest is it should be 6%, 9% has been granted, and sorry, and there's error in
Seems
calculation.
that you have not yet recovered from your cough and cold.
No, I have not. And my last ground is, my lord, this calculation, my lord. As per the correct calculation, the award will be 13,51,087 rupees. I'll give the exact amount.
31 lakh, how much is awarded?
15,31,087.
15,31,000.
087 has been awarded.
Yes.
That will reduce by 2 lakh. That will be 31,51,000.
No. 15,31,087 is already awarded.
Yes,
Yes.
there's error in calculation.
Yes.
As per the correct calculation, it should be 13,51.
13,51.
087.
087.
I'll still make a fresh calculation before.
So if it is a calculation,
Yes,
this
there's.
is the ground for review and rectification.
But since
the court which has passed the award can also correct the same.
Yes, but my lord, only thing is that since there are other grounds also.
Okay. So if the computation and the procedure is accepted, it comes to 13,51,087.
My lord, I'll still recheck once more, but it will come down. Yes. And regarding this non-involvement, my lord, this Honorable Supreme Court has directed all the states, my lord, to form this special investigating team, my lord. SIT.
Yes.
My lord. Judgment it's 2021 18 SCC 813 copy name 2021 18 SCC 813 Shafiq Ahmed versus ICICI. I take to my lord.
Yes.
In UP, my lord, more than 1,300 cases. I'll just give the gist of this matter, Shafiq Ahmed, my lord. More than 1,300 cases were found to be fake and fraudulent, my lord. There are certain directions which had been passed by the Honorable Supreme Court, my lord, directing all the states, my lord, to form a SIT in connection with this MSC cases, wherein, my lord, the head note, my lord, will kindly see once. Head note B. I'm sorry. Fake compensation petitions, considering further suggestions on behalf of certain insurance companies. So it's in connection with fake compensation petitions, my lord. Thereafter, my lord will kindly come to paragraph number 8. 8 to 8.1.11. Paragraph number 8, my lord, internal page number 819. Herein, my lord,
8 point paragraph number?
8 onwards.
Yes.
Paragraph number 8 onwards, my lord will kindly see that it's given the heads on which false claims are made, my lord. They are given in these paragraphs, my lord, and has been dealt with. There are a number of heads, my lord. Non-death, non-road accident injury dash death converted to road accident claims, fraudulent implantation of vehicle, false implantation of driver, claimant implantation.
8 and 9.
8, it continues, my lord, till 8.1.11. That is at page 822. So a number of heads have been mentioned in this judgment, my lord, under which frauds are being committed, and the states, my lord, different states, they have been instructed, my lord, directed to form this team, special investigating team, my lord, so that these cases can be found out and investigated. Based on this judgment, my lord, Honorable Justice Ananya Bandapadhyay, when her ladyship was having determination to take up these MACT appeals, FMA 337, 2024.
Yes.
Shundha Nayak versus National Insurance. My lord, in this matter, my lord, this matter was referred to sit. This is pending. I pray before my lord will kindly come to the last page, my lord. I'm sorry. The department is directed to send a copy of the entire case records to the Office of the Additional Director General and Inspector General of Police, Traffic and Road Safety, West Bengal, to place the entire case records before the SIT constituted for investigation of suspicious / fake motor accident claim cases within a fortnight. This matter is pending, my lord. I pray before my lord, this matter before us today, my lord will kindly refer this matter also to SIT, my lord. If SIT gives a report in favor of the claimants or the owner, my lord, my case goes. But all I am on is, my lord, that insurance company should not be penalized, my lord, for no fault of insurance company. It is true we have not adduced any evidence, my lord, but facts, on the basis of facts, on the basis of documents which have been charge sheeted by the claimants, and they are matter of records before the court, my lord, we should not be penalized, my lord. Facts point that maybe there's implantation in this case. If the SIT gives report which is in their favor, my lord, my case goes. I don't have anything more to say. I humbly pray before my lord, let this matter go. My lord will keep it returnable. Let them give a report.
Anyway, that I shall consider.
My lord, I'm grateful, my lord. This is my submission.
Yes, who is for the? You are for the? Yes, let me hear him. The vehicle owner.
My lord, our learned friend has, put forward some serious allegations on the respondent number 2. So I need some time to take instructions from the respondent and come back to the court.
How long will you take?
2 weeks, my lord.
2 weeks time you require.
So I can
The
prepare.
matter is filed long time ago.
Yes, my lord. At least a week, my lord.
Okay, record. Learned advocates for the parties are present. MS Pal has concluded her submission. Appearing for the appellant has concluded her submission. Learned advocate appearing. You are for respondent number 3.
Respondent number 2, my lord.
Respondent number 2, vehicle owner.
Yes, my lord.
Prays for time to take instructions. Let this matter appear on 15/1/2026 at 10:30 a.m. as a specially fixed part heard matter.
But since he is paying time, I have nothing to say. But since there is no pleading on that issue by them,
Anyway, you see,
here it
insurance company has made submission.
Only
If he has to controvert some
that's
submission
true. But
allegations,
they have the pleading regarding implantation. This issue cannot be raised. It is not a law point. It is a factual aspect.
okay,
It cannot be raised in this way.
Okay, come on 15th, it will be
15th,
taken up
okay.
at the.
Grateful, ma'am.
I'm grateful, my lords.
করে ঢোকানো তো। Yes, item 29. Okay, not today. সিরিয়ালি কল করুন। একটা দুটো সিরিয়ালি কল করুন, তারপর 12টার ম্যাটারে আছে।
Lordship, this is my appeal, your lordship. Appeal is filed within time, your lordship. This is my statutory.
There's an application for stay.
Stay.
Yes, রেকর্ডটা দেখি। Yes, record an order. Learned advocate for the appellant is present, as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an interim order of stay of the judgment and award dated 24th September 2025, passed by learned additional district judge, Fast Track Second Court, Barhampur, Murshidabad, in MSC claim case number 315 of 2017 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest, as directed by the learned trial court, excluding the statutory amount, within period of 5 weeks. Stop. In the event the deposit is made within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Liberty to mention.
This item, my lord, I am appearing for the petitioner. Your lordship, I am praying for not today on ground of senior counsel, Mr. Supratik Shamul.
Some applications are to be disposed of.
I am for the respondent, my lord. This is a suit for eviction of a trespasser. But suit property relates to a trigger tenanted property.
Anyway, this court has to take up only the Section 5 application.
My lord.
The matter is not yet admitted. Appeal is not yet admitted.
No, appeal has been admitted.
So
Not
how it is?
Section 5.
So how before Section 5 the appeal will be admitted? Section 5 has to be decided first. Thereafter, it will go to the division bench for admission.
But it has already been admitted.
So how Section 5 remain? If the appeal is admitted?
Section 5, my lord. Item number 18.
Yes, 18. What is this? Can 1?
Can 1, my lord, for extension of
For
interim
extension, my lord.
Okay, and
Can 1, can
3?
2, and can 3 for extension of the interim order.
Okay, let it be not today.
Malad, kindly fix a date for hearing it.
Not today, it will appear in the, it will retain its position.
Obliged, Your Honor.
Tomorrow, my lord.
Obliged, Your Lordship.
19. Lord, I am for the opposite party. Yes,
Yes, I think Mr. Pinaki Mitra
Yes,
was
yes,
here.
Mr. Mitra was there, my lord, prior to my lord taking up your lordship's 10:30 matter.
So,
make it not today or not this week.
okay,
my lord.
not today.
Great.
My lord, 20, my lord, I am for the petitioner, my lord. My lord, this is an application under section 5 of the Limitation Act for condonation.
Service is complete upon the our respondents.
Well, there is no such direction passed by this court as
No, for considering section 5, service has to be completed.
my lord, I have served notice, but my lord, most of the envelopes came back with an endorsement that not claimed or.
Let me see.
Actually, my lord, what has happened, my lord? Actually, there was no delay, my lord. Judgment passed on 37.
No, there is, as per the stamp reporters report, there is a delay.
My lord, I am telling you, lordship, my lord. My lord, 37, 2024, my lord.
How long? How many days delay?
My lord, as per my lord,
No, you have
55 days.
Yes,
55 days.
55 days. Let me see what happened with regard to service.
My lord, I could not file the affidavit of service because my lord, most of the envelope came back, my lord.
You state that the 60 as per the 66 delay as per the report of the stamp reporter. Why, according to you, there is no delay?
Well, according to me, my lord, there are some application after passing of the degree, an application for amendment has been filed for correction of the degree. My lord, that application, my lord, was amendment was passed on 21/11/2024, my lord.
Is that
If that
time
be taken
excluded?
into account,
No. Can time be excluded on that ground? Time cannot be excluded on that ground.
But that is why, my lord, I have explained, my lord. I have explained.
Anyway, very well. Now,
I have
you file your affidavit of service. All the envelopes have returned.
No, my lord, not all the envelopes, most of the envelopes, my lord. Because my lord, there are total 100 parties, my lord, your lordship.
No, obtain a track report. You have not served all.
My lord, I have served all, my lord. My lord, if your lordship kindly come to page 16, paragraph 2 onwards, my lord.
Page 68.
Page 16, my lord, paragraph 2 onwards of the section 5 application. Section 5 application, can yes.
Page 16.
Page 16, my lord.
Yes.
My lord, I have stated onwards, so I have stated the everything, my lord.
Very well. Section 5 has to be decided upon
My
service
lord,
of
actually, my lord, after passing of the amendment of degree, my lord, degree has been amended and my lord, degree was passed, my lord, fresh degree was passed, my lord. If that your lordship take into account, there is no delay. But I have explained, my lord. I have explained.
That will be considered, but other side has to be given notice. But all the envelopes have returned.
Not all the envelopes, my lord. I am not telling
How
that
many,
most
how
of the
many
envelopes.
respondents are there?
My lord, your lordship, can you see the number of respondents?
All have appeared before the learned trial court and the
No,
appellate
my
court.
lord, no. Very difficult for me to, my lord, calculate who have appeared or who have not appeared.
So it's better you do one thing, you obtain a track report and then you file an affidavit of service. No, you obtain a track report, okay? And then you file the affidavit of service.
Then, my lord, I have to file a fresh, my lord, because your first track report time has expired, my lord. Perhaps it is 30 days or like that.
How many envelopes have returned unserved?
My lord, I have to take most of the envelopes returned, my lord.
Otherwise, there have to be some substituted service. Or you can do one thing, you can serve the learned
advocate in the court below.
Yes, advocate in the courts below. Okay.
That your lordship kindly direct.
Yes, record an order. Learned advocates for the appellant is present. It is submitted by the learned advocate for the appellant that upon notice being issued to the respondents, most of the envelopes have returned unserved. In the facts and circumstances, learned advocate for the appellant is granted an opportunity to serve the learned advocate appearing before the appellate court, first appellate court.
Yes, my lord, first appellate court.
Appellate court within 2 weeks.
Yes, my lord, 2 weeks.
Let this matter.
My lord, by this month, during this month, my lord, during this is Murshidabad, my lord.
2 weeks.
2 weeks. All right, my lord, 2 weeks.
I'm granting you 2 weeks time to serve the
Learned advocate before the learned appellate.
appellate court. Let this matter appear on 27/1/2025.
My lord, I'm grateful, my lord.
ফাইল করো টাইম 21 ফাইল তো টাইম
My lord, I'm appearing for the appellant. I'm being led by Mr. Probal Mukherjee. He'll be here, my lord.
I think he's on legs, my
He's
lord.
on.
Continue with your lordship's regular list. He's coming within a
Yes,
minute.
Lord.
Pass over. Pass over.
Item number 21. I'm for the respondent, my lord. One, well, may I file the opposition, my lord, to the section 5 application, my lord?
Yes, record an order. Learned advocate for respondent number 1
Yes, yes.
is present. The affidavit in opposition to section 5 application file be kept with the record. Leave is granted to file affidavit in reply within 1 week. Let this matter appear on 15/1/2026. A copy of the affidavit in opposition be served upon the learned advocate for the appellant. In the meantime,
We have not been added yet.
well, I have filed the application, but you are before the court.
Yes.
It is a procedural matter to add you or not to add you, but you are before the court.
Yes.
You see, in original side, in so many matters, the parties intervene. They are not added, but they are permitted to intervene as purchaser or necessary. Without
to be filed.
Yes, that application is filed,
Yes.
and most of the time they are permitted to intervene. Not even a party also.
No. But that application is required.
Application is required.
Something is required on record.
My lord, kindly take some my can see, my lord. Perhaps have the copy, my lord. Okay, yes. I have prayed for adding them, my lord, as a party respondent.
So let the section 5 application be taken up. You whatever you submit.
Addition of party.
Yes.
Come to paragraph 2.
Yes.
The degree was passed by the appellate court on 29/4/22. And kindly come to paragraph 5.
Yes.
The sole respondent expired on 24. So after the degree, she expired.
Anyway, that is a question of law, whether under Order 1, Rule 10(2), it can be added or not. That's a question of law. But that point is kept open. But
Section 5, Your Lordship.
now, question is, you submit on Section 5. If I find this application not maintainable, the entire Section 5 will go. Okay.
Yes.
And if it is maintainable, Section 5 has to be disposed, either allowed or rejected.
Yes.
So it's better you submit on Section 5.
Section 5, I have to give affidavit because facts are disputed.
Section 5, you have not.
You
have been served with a copy. Yes, record
Because
an order.
it has not been added as a party, how can I file
Yes.
the opposition?
Now the question is, you see, If you want, I can today itself add you as a party because you are before the court.
Yes, yes.
And then keep that section 5 open.
Yes.
Yes, learned advocates for the plaintiff, for the appellant,
my lord.
and learned advocate for the party, for the heirs of the
Consent.
no, but of the heirs of the deceased respondent,
Sole respondent.
deceased sole respondent
My
are
lord.
present. The appellant has sought to bring into record the heirs of the deceased sole respondent who has died prior to the filing of appeal by filing an application under Order 1, Rule 10.2 of the Code of Civil Procedure, being Can 3 of 2026. So although this petition is objected by Mr. Srivastava, learned advocate appearing for the heirs of the deceased respondent, but considering the fact that the heirs has already been served and is before the court, and considering the provisions of Order 1, Rule 10.2 of the Code of Civil Procedure, where the court in the interest of justice can add necessary parties, this application stands allowed.
Grateful.
Let necessary amendment be carried out by the department within 1 week. Mr. Srivastava prays for time to file written affidavit in opposition to Section 5 application. Such time is allowed. Let affidavit in opposition be filed on or before 14/1/2026. Reply, if any, by 16/1/2026. Let this matter appear on 19/1/2026.
My lord, may I prefer instead of 16, may it be 19, my lord. I will file within 19, my lord.
Let it come on, give me an advance copy.
Okay.
Then he can do.
Okay, 19th,
19th, let it appear.
by 19/1/2026, let this matter appear on 20th January
My lord.
2026.
My lord. Grateful to you.
Advance copy may.
Yes, advance copy must be served.
My lord.
Advance copy be served. लिखे दिन, advance copy be served.
The Can 3 is disposed of.
Yes, Can 3 stands disposed.
Grateful to you, sir.
My lord, 24, I beg to appear for the appellant, my lord.
For the respondent number 1.
But I served all the respondents. But so far as my lord, track report shows that respondent number 2A, 2B, 2C, 3 and 4 is not been served since 12/12/2025. I don't know is there any server problem.
You are for?
I am for the my lord, appellant
Petitioner.
applicant.
And you are for?
I'm for respondent number 1.
Because they filed a caveat, so
Caveat,
I
huh.
served them directly, my lord.
No, Section 5 application has to be served upon
I
all.
have served all
For
of
the
them.
purpose of admission, if there is no caveat, you need not serve. But for Section 5, you have to serve all.
I have served all. But my lord, track report shows that respondent number 2A, 2B, 2C, and 3 and 4, since 12/12/2025, there is no my lord, tracking ID of those parcel, my lord. Din affidavit of service is unique to my lord case. And perhaps, my lord, Section 5, I have to withdrawn because, my lord, I have checked up. SR says that there is no delay. But according to my calculation, 2 days delay.
No, but as per the report, no delay.
Delay, perhaps, my lord, subject to correction, my lord. Is there a report?
Yes, affidavit of service, what have you stated?
My lord, affidavit of service, I have, it was received so far as, my lord, respondent number 1 is concerned.
I'm appearing. I
And
filed
so far as, my lord, respondent number 2A, 2B, 2C, 3 and 4 is not received yet because there is no, my lord, update in the tracking ID after 15/12.
The period of delay is 2.
According to my calculation, 2. But according to SR, my lord, perhaps there is no delay. May I check it, my lord?
Yes.
I can record the SR report and dismiss my. My lord can record it, then I will withdraw my.
The record দেওয়া আছে, that is
পিছনে endorsement আছে। ওইটাই। না ট্যাগটা ঢুকে দিই। সার্টিফাইড কপির মাঝখানে দুদিনের ডিলে হয়ে গেছে। অর্ডারটা পাস হয় 24/10-এ, আমি অ্যাপ্লাই করি 21/11-তে, কপি হ্যান্ড ওভার করে 26/11-তে, আমি ফাইল করি 2/12। অ্যাকর্ডিং টু মাই হিসাবে হচ্ছে ওই ভ্যাকেশনের দুদিন পড়ে গেছে। Because my lord, the first appellate court passed judgment and decree on 24/10/2025. My lord, I applied for certified copy on 21st/11/2025.
There are certain other defects also, which are to, have you removed the other defects?
All the defects are removed.
Okay. Because it is also stated decree of the appellate court may be sent for necessary rectification.
That, my lord, departmental, my lord, I can't correct it.
Yes, record an order. Learned advocates for the parties are present. As it appears from the report of the stamp reporter that there is no delay, the application under section 5 of the Limitation Act filed has become infructuous and stands disposed.
Can 1, my lord. Can 1 of
And 1 of
2025.
2025 stands disposed, my lord. Let necessary steps be taken by the department to register the appeal. After necessary rectification is made with regard to the notes given.
By the SR, my lord.
Yes, by SR.
Because, my lord, if there is a defect in the decree, it has to be sent.
Yes,
to
yes, that is why after necessary steps are taken for rectification.
Grateful.
I apologize, Lord. I was late, Lord.
You are for the appellant.
But I am for the appellant. Lord, I started the matter on the last occasion. Well, I'll just refresh your lordship, Lord. I am the tenant defendant in the suit for eviction on the ground of default, reasonable requirement, and Lord, violation of MOP of 108 of Lord, the Transfer of Property Act. And also there was an allegation of change of user. The trial court dismissed the suit on the ground that Lord, none of the grounds sought to be proved by the plaintiff could be proved. But the appeal court had reversed only on the ground of reasonable requirement. This is a flat measuring about 1606 square feet, not in a multi-storied building, wherein my client is staying. Previously, my client's husband was staying with my client, the present client, and they were running a speech therapy unit there.
How many rooms were there in the suit
Lord,
property?
this particular property, which is the subject matter of the suit, has never been inspected. There was no commission held. So, Lord, I cannot, Lord, from the records, Lord, give your lordship, Lord, the exact, Lord, the topography of, Lord, the flat. But I can indicate, Lord, that how many rooms are there from my client. Lord, on the last occasion, I read up to, Lord, page 47. So, Lord, the issue number 5 and 6 of the trial court, this is the issue by which, Lord, the trial court dismissed and found, Lord, the case made out by the plaintiff cannot be believed.
Yes.
But may I start from page 47, Lord, issue number 5 and 6?
Because that is the, I think this is the ground for eviction.
Lordship.
Issue with regard to eviction.
This was, Lord, this was by the trial court. Trial court, Lord, did not believe, Lord, what the plaintiff wanted to, Lord, prove. The appeal court reversed it.
That is why, that is the issue you see on the points framed, on the grounds framed.
My lord.
The appeal has to be heard out. The second appeal has to be heard out.
Yes.
Whatever is framed.
Yes. Lord, after I place before your lordship about, Lord, the reasonable requirement and the bona fide of the reasonable requirement, then, Lord, I will address your lordship, Lord, on the points of law, Lord, on which the appeal has been admitted. না ওটা কতগুলো ঘর 1606 তো আমি বলে দিলাম কিন্তু কটা ঘর যশায় জিজ্ঞেস করছে কমিশন রিপোর্ট হয়নি এটাতে তাই জন্য আপনি পাবেন না ক্লায়েন্টের কাছে জেনে বলুন but I'll just not take information Lord pursuant to my lord's query Lord on the number of rooms
Number of rooms. Area
because
is
there's
1506
306 and there is a terrace of
because it
300
is used for residential purpose.
residential part and part is not for the speech therapy unit which was not part of the agreement itself
Okay. So 2 rooms. Number,
maybe more than 2 rooms
maybe 3
1606
rooms.
is not required more than 2
So partly residential, partly non-residential.
partly yes that was
Anyway, that was part of that agreement also.
lordship and that has been found by both the courts that it was part of the agreement so there is no change of user per se
Right.
On the question of default it was found that I am not a defaulter or the question of Lord the change of Lord the nature and character it was found that I have not changed the nature and character of the suit property to attract MOP of 108 no I am addressing on a different point user what a user commercial tax aspect not a user person
Yes, what is the age of this person?
But,
Widow, this age
this is a widow
Yes, age.
but the age is about almost 80 years but there are 3 bedrooms, 1 dining, dining, 1 kitchen, and 3 bathrooms. So 3 bedroom, 3 bathrooms, 1 dining area, and a kitchen.
Okay, 3 bedroom, 1 dining room.
Yes. Dining comes sitting. That is 1 hall.
Because you see, in the bedroom, that speech therapy cannot be held. For that, a separate sitting room or a hall is required.
Yes, that is there.
So 3 bedroom, 1 dining room, and 1 kitchen.
But that is the dining come, not the sitting room. That is how it is. Hall. That is a hall. 1 kitchen.
My instruction is that they are separate. Dining is separate and the drawing room is separate.
You could have asked for a commission. It was the plaintiff's duty to hold a commission. That is one of my point, basically.
No, in the second appeal stage also, sometimes it is done in exceptional cases.
Now that, Lord, that the trial court was against them. The appeal court, Lord, reversed it without a commission held. The commission was German because of the fact, Lord, to see, Lord, the exact, Lord, the usage, reasonable requirement. My Lord knows about the requirement of a commission. Also for the purpose of, Lord, to explore the possibility of partial eviction, which is the statutory mandate. Because on that scope, Lord, it was admitted. Therefore, without a commission, Lord, straight when the first appeal court, Lord, passes a degree on the ground of reasonable requirement, Lord, that in my respectful submission is per se a perverse judgment.
Yes.
Now, Lord, your Lordship will kindly come to page 47, Lord.
47, yes.
The paper book.
Yes.
Both these issues being interrelated with each other are taken up together for discussion for the sake of brevity of discussion and to avoid unnecessary repetitions. In the plaintiff has claimed that the plaintiff reasonably required the suit premises for its own use and occupation and has further stated that the plaintiff is carrying on business as non-banking financial corporation and there are 9 staff in the plaintiff organization including manager and assistant manager, and as per the terms and condition of service, the plaintiff is to provide residential accommodation to their senior staff and manager and assistant manager. It is the case of the plaintiff that since the plaintiff does not have any accommodation of their own for providing residential accommodation of their senior staff, plaintiff is providing rented accommodation on 11 months leave and license basis to the senior staff and thus incurring huge cost towards payment of leave and license fee. Plaintiff has claimed that in spite of having ownership in respect of the suit premises, the plaintiff is incurring a huge amount every month towards payment of rent license fee and other charges, and as such, the plaintiff has claimed for eviction from the suit premises so that the suit premises can be provided to the manager and assistant manager for their own residential accommodation. In the written statement, defendant has changed the requirement of the plaintiff. Arun Kumar Sancheti, who has been examined as PW1, is one of the directors of the plaintiff company, has exhibited Exhibit 16 and 17, which were leave and license agreement and rent receipt to show that the plaintiff company has acquired rented premises for its employees. At the time of argument, learned advocate on behalf of the defendant vehemently argued on the point that from the plaint and the examination in chief filed by PW1, it will be evident that the plaintiff has an accommodation at 8 Kamak Street. There is no averment in the plaint as to in which capacity plaintiff occupies 8 Kamak Street and what accommodation is available at 8 Kamak Street. No commission work was held at 8 Kamak Street. That apart, learned advocate on behalf of the defendant canvassed on the point that there is no document to show that the persons for whom the suit premises has been claimed are residing at the rented premises of the company. He has vehemently argued on the point that the premises which was inspected by the learned advocate commissioner were the personal property of Arun Kumar Sancheti, that is director of the plaintiff company. There is nothing on record to show that the plaintiff company does not have any other accommodation. That apart, from the cross-examination, it will be evident that during pendency of the suit, plaintiff company sold out certain flat. He is of the opinion that if the plaintiff company required the suit premises to accommodate its staff, then why did the plaintiff company sell out other premises during pendency of the suit? Learned advocate on behalf of the defendant further argued on the point that from the cross-examination of PW1, it transpires that the suit premises is required to accommodate Naveen Setia and that Naveen Setia was a constituted attorney on behalf of Sudha Vaid, vendor. And Naveen Setia is the same person for whose accommodation plaintiff company has filed the suit. But I'll explain this at a later stage because the bona fide is a question here. He further argued on the point that the appointment letter of Naveen Setia was signed by Prakash Sharma and Prakash Sharma signed as director for the confirming party, that is Mrs. Rosewood Merchants Private Limited. In the deed of conveyance, with which the plaintiff company purchased the suit premises, he has claimed that there is an unholy alliance between those parties and the deed of transaction is a sham transaction only for the purpose of evicting the defendant. Countering the claim of the learned advocate for the defendant, learned advocate on behalf of the plaintiff argued that the plaintiff has produced Exhibit 16 and 17 to show that the plaintiff has rented certain premises for the directors of the company and that there are 4 lease deeds which have been marked as Exhibit 16 collectively to prove that the staff of the plaintiff company was residing at those rented premises. On perusal of the plaint, I find that it has been mentioned that the suit premises is required for accommodating senior staff of the plaintiff company, that is the manager and assistant manager. In cross-examination, PW1 stated that he requires the suit flat to accommodate Naveen Setia and Arun Kumar Vaid. In support of his claim, he has produced the appointment letters of Naveen Setia and Arun Kumar Vaid, which have been marked as Exhibit 15 collectively. From the appointment letter of Naveen Setia dated 1/11/2013, I find that in the last paragraph, it has been mentioned, your appointment shall be on a probationary basis for a minimum period of 6 months, which may be extended if required. During this period, you will be given a compensation package, CTC, that is cost to company, of rupees 15,000 per month with rent-free accommodation. And from the appointment letter of Arun Kumar Vaid dated 3/4/2012, I find that it has been mentioned, your appointment shall be on a probationary basis for a minimum period of 6 months, which may be extended if required. During this period, you will be given a compensation package CTC of rupees 15,000 per month. After 6 months of your job, company provide you rent-free accommodation. So from the appointment letter of Naveen Setia, I find that it has been mentioned that he has been appointed on a probationary basis for 6 months and during this period, he will be provided with rent-free accommodation. He was appointed on 1/4/2013. So from 1/4/2013, the period of 6 months is 39/2013. So the suit premises was required for the period 1/4/2013 to 39/2013 to accommodate Naveen Setia. There is nothing on record to show that Navin Setia was required to be provided with rent-free accommodation after expiry of 6 months as per appointment letter Exhibit 15. In the given premises, the requirement of plaintiff for the purpose of accommodating Navin Setia cannot be taken into consideration. The next limb of argument of the plaintiff was for the purpose of Arun Kumar Baid, and from the appointment letter dated 3/4/2012, I find that the terms and condition of appointment was that after 6 months of the job, the company will provide rent-free accommodation. From the terms and conditions which are annexed to the letter of appointment, I find that it has been mentioned that your engagement will be on probation for a period of 6 months. Extension will be at the discretion of the management, during which service are liable to be terminated without any notice or reason. There is nothing on record to show that Arun Kumar Boyd has completed the probation period satisfactorily, because no confirmation letter of Arun Kumar Boyd has been produced before this court. There is nothing on record to show that Arun Kumar Boyd is continuing in service. PW1 could have produced the acquittance roll or the PPF deduction slip or salary statement to show that Arun Kumar Boyd was continuing in service of the plaintiff company. That apart, there is nothing on record to show that Arun Kumar Boyd was occupying the rented premises of the plaintiff company. Though the plaintiff has produced 4 leave and license agreements which have been marked as Exhibit 16 collectively, I am compelled to hold that the license deeds have not been proved as per provision of Section 43, 47, 67 of the Evidence Act. If the plaintiff wanted the court to rely on these documents, then the plaintiff should have called either the executor of those documents or any person acquainted with the signature of the licensors, and should have exhibited those documents as per law. But since those documents which have been marked as Exhibit 16 collectively had not been exhibited as per provision of law, and the signature of the licensors have not been proved, hence I am not inclined to rely on those documents. Learned advocate on behalf of the defendant at the time of argument argued on the point that the plaintiff has accommodation at 8 Kamak Street is evident from the cause title of the plaint, and the plaintiff did not pray for inspection of 8 Kamak Street. I totally agree with the view of learned advocate for the defendant that there is nothing on record to show the accommodation available to the plaintiff at 8 Kamak Street. Premises number 8 Kamak Street was not inspected. But there is nothing on record to show that 8 Kamak Street is exclusively used for the purpose of the plaintiff company. It is the duty of the plaintiff to bring the true picture of accommodation available to the plaintiff at 8 Kamak Street. Then the accommodation available to the plaintiff at 8 Kamak Street would come before this court. In absence of the true picture of 8 Kamak Street, I am not inclined to hold that the plaintiff does not hold suitable and reasonable accommodation, because the court cannot come to a conclusion on surmise and conjecture. Since the plaintiff has asserted that the plaintiff does not have any other suitable and alternate accommodation, and the defendant has pointed out that from the cause title of the plaint, it will be evident that the plaintiff has accommodation at 8 Kamak Street. So the burden of proof was upon the plaintiff to show that the accommodation available to the plaintiff at 8 Kamak Street is not suitable, reasonable alternative accommodation. Since the plaintiff did not discharge its burden of proof, I am not inclined to believe the case of the plaintiff, and plaintiff does not have any other alternate suitable accommodation. Hence, in view of my above discussion, I am compelled to hold that the plaintiff has failed to prove that the plaintiff has requirement of the suit premises for Navin Setia and Arun Kumar Baid, or that the plaintiff does not have any other alternate suitable accommodation. Hence, both the issues are decided against the plaintiff and in favor of the defendant. Now, my lord, I am not taking your lordship, my lord, to issue number 7 and 8, but only that portion, my lord, at paragraph 60, my lord, in that page, because this was decided against the plaintiff, and my lord, paragraph 60 at page 54 itself.
Yes.
On perusal of clause F of Exhibit 9, that is a deed of agreement dated 15/5/1975, that is the parent tenancy agreement, executed by and between Ashok Kumar Baid, Hira Kumari Baid, and Shudha Baid on one part, and Mr. Texan Sayo, that is the husband of my client, present client, on the other. I find that it has been mentioned the said flat will be used strictly for residential cum clinic purpose. However, with residence, doctor's chamber can be added in that flat, such as optometric clinic and speech therapy clinic. But in any event, the flat has to be used for residential purpose also. There is nothing on record to show that the flat is being used exclusively for speech therapy clinic and that the defendant is not residing at the suit flat. Since the plaintiff failed to show that the flat is being used exclusively for speech therapy clinic, I am compelled to hold that the plaintiff has not been able to prove the allegation labeled in the plead. Now, my lord, kindly come to my lord, page 56, paragraph 66.
Page 56, para?
Para 66.
63.
66, my lord.
66, yes.
66. Thus, taking a bird's eye view of my above discussion, I do hold that the suit is maintainable in its present form and prayer, and that there is a valid cause of action to file the instant suit, and that the notice of eviction is legal and valid, and the same was duly served upon the defendant, and the defendant is not a defaulter in payment of rent. But however, the plaintiff has failed to prove that the plaintiff reasonably requires the suit premises for his own use and occupation, or that the plaintiff does not have any suitable and alternate accommodation, and the plaintiff has also failed to prove that the defendant is guilty of change of mode of user of the suit premises, and that the plaintiff has acted contrary to the provisions of MOP of section 108 of the Transfer of Property Act, or that the defendant is guilty of conduct of Act of West. And therefore, not the suit failed. But we'll kindly come to the decree at page 62. Now I have to relate the suit property with the property which we have not inspected, and the alternate property at 8 Kamak Street. So, your lordship will kindly take note of the suit flat and the address.
Page 63.
Page 62, my lord.
Page 62, yes.
Page 62. So, my lord,
this is the suit flat.
Suit flat. Flat number 1A, Nilkant Building, first floor, 26B, Kamak Street.
No, this is in which area? This
Kamak Street.
Both are on Kamak Street.
Both are on. The other one, your lordship will find 8 Kamak Street, Shantiniketan Building.
Okay.
And in this particular 26B Kamak Street, there are other 2 flats which were inspected, 10A and 10B.
Okay. In this proceeding.
In this proceeding. That is the evidence of PW2, the court commissioner. But not in respect of the suit flat. In respect of 8 Kamak Street, there were no attempt at having a commission to show that the office that they are having there is insufficient to accommodate any of their offices.
Yes. Yes.
আসছি দেখ Your lordship will kindly take the appeal court judgment. That's the judgment of reversal. But that is at page 66, it starts. Kindly come to page 68.
Yes.
The case of the plaintiff appellant herein in ejectment suit number of 2013 is that the plaintiff is a private limited company carrying on business from its office, being room number 503A on the 5th floor at Shantiniketan Building, 8 Kamak Street, which is entirely used for commercial purpose. Further case of the plaintiff is that the plaintiff company has become the absolute owner of flat number 1A, first floor at Nilkant Building, measuring about 1606 square feet, more or less, together with 300 square feet open terrace, lying and situated at premises number 26B Kamak Street, by way of purchase from Srimati Sudha Baid by virtue of a registered deed of conveyance dated 18/11/2011. The defendant is a monthly tenant in respect of the said suit flat at a monthly rental of rupees 2,475 payable according to English calendar month from the period of previous owner in pursuance to an agreement dated 15/5/1976, and the suit premises was let out for residential purpose. After purchase, the plaintiff's vendor, Srimati Sudhabai, sent a letter of adornment on 17/1/2012 to the defendant, directing the defendant to adorn the name of the plaintiff and to pay monthly rent directly to the plaintiff. But in spite of the receipt of the said letter, defendant did not pay any rent to the plaintiff. Rather, the defendant deposited rent at the rate of 2,475 per month in the name of Sudhabai at the office of the Learned Rent Controller, Kolkata. Further case of the plaintiff is that the previous owner Sudha Boyd had filed an eviction suit against the defendant, being ejectment suit number 524 of 1983 in City Civil Court, Calcutta, which was subsequently transferred to the Court of Small Causes, Calcutta, and was renumbered as ejectment number 504 of 2001. Srimati Sudha Baid had also filed an eviction suit before the Honorable High Court at Calcutta, being CS number 01 of 2004. Under misconception of law, which was ultimately withdrawn by her on 10/4/2013, with permission of the Honorable High Court at Calcutta, with liberty to file a fresh suit. But on this score, Lord, I will just make a small submission. Your Lordship has seen, Lord, this withdrawal of the suit in the High Court, it was in 2013. Property was sold in 2011.
So these were before the trial court, these issues. Whatever
These were, and from the evidence I'll point out. From the evidence I'll point out before your Lordship. Lord, this goes to the root about the bona fide of the requirement. So, my Lord, the vendor of the plaintiff Sudhabai, Lord, before this honorable court, Lord, asked for withdrawal of the suit with liberty to file a fresh suit, without indicating that she has already sold the property in 2011. Subsequently, fresh notice was issued on 22/4/2013, which was duly received by the tenant on 25/4/2013. And as the defendant did not quit and vacate the suit premises, the defendant has filed the instant suit on the ground that the defendant is a defaulter in payment of rent in respect of the suit premises from November 2011, and that the plaintiff reasonably requires the suit premises for his own use and occupation, as the plaintiff is a non-banking financial corporation having registered office at 8 Kamak Street, Kolkata 70. It is a further case of the plaintiff that the plaintiff has 9 staff employees in their organization, including manager and assistant manager, and that in terms of the service contract, plaintiff has to provide residential accommodation to the senior staff, namely manager and assistant manager. Accordingly, those senior staff were provided rented accommodation on 11 months leave and license fees, which the plaintiff has to incur huge cost towards payment of license fee every month. And so the plaintiff requires the suit premises to provide residential accommodation to the manager and assistant manager. It is a further case of the plaintiff that the plaintiff wants to diversify its real estate and iron and steel business, and for which the directors and promoters have already invested 2.5 crore by way of share capital during the last 2 years, and for that, more staff would be needed, and the plaintiff would have to provide residential accommodation to those staff also. It is further allegation of the plaintiff that the defendant is conducting speech therapy center, which is purely commercial activity from the suit premises.
Now, in this regard, the agreement also provides
optometry or speech therapy.
Yes.
Husband was not an optometrist. The wife, my client, is a speech therapist, special educator.
The Chinese community.
No, she is not Chinese. The husband was Chinese.
Husband was a Chinese.
Sikkimese. Husband was Sikkimese. I'm told her husband was Sikkimese. And the wife, my client, she is not. It is a further allegation of the plaintiff that the defendant is conducting speech therapy center, which is purely commercial. Plaintiff has therefore alleged that the defendant has acted in contrary to the agreement of tenancy and is entitled to evicted of being guilty of violation of clauses MOP of 108 of the Transfer of Property Act. It was further the affirmation of the plaintiff that the defendant has made special conversion. Without obtaining any written permission from the plaintiff has further alleged that the defendant is guilty of waste and negligence and causing mental deterioration of the condition of the suit premises. Plaintiff has inter alia prayed for a degree of recovery of khas possession, stating the cause of action to have arisen from 1/6/2013. The defendant respondent herein contested the suit by filing written statement and thereby denied all material allegation made in the plaint. It is a positive affirmation of the defendant that the defendant was inducted as a tenant by the landlord Ashok Baid, Hira Kumari Baid and Sudha Baid in respect of suit flat at a monthly rental of rupees 3,000 including maintenance charges of rupees 900. That one of the landlords, namely Hira Kumari Baid, died, and after her death, the defendant became a tenant under Ashok Baid and Sudha Baid. It is a further case of the defendant that the erstwhile landlord filed a case being number 21 of 1978 against defendant for recovery of arrears of rent in Small Causes Court, Calcutta. And the said proceeding was compromised, and as per compromise, rent was reduced to 2475, including maintenance charges, lighting of common passage, staircase, and all services, and the defendant paid the said amount to the landlord up to May 1982. And thereafter, the owners' association has threatened the defendant for disconnection of essential services, as the defendant did not pay the corporation tax and service tax to the association. Defendant filed a title suit being number 1639 of 1982 against the erstwhile landlord, and the defendant had preferred FMA 1001 of 1982 against the order dated 14/10/1982, an order dated 23/8/1983, and the Honorable High Court, Calcutta VD order dated 2nd February 1989 directed that the defendant would pay to the owners' association the actual liability of the owner and the balanced amount of rent in the City Civil Court, Calcutta, and in terms of the said order, the defendant started to pay corporation tax and maintenance charges to the owners' association and rupees 819 in the suit to the credit of the erstwhile landlord. It is the further case of the defendant that subsequently Sudha Baid, claiming herself to be the sole owner of the premises on the basis of a deed of conveyance dated 22/2/2001, filed suit against the defendant, praying for a degree of recovery of khas possession of and other relief, and during pendency of the said suit, Sudha Baid informed the defendant that she sold the suit flat to the present plaintiff, and with a letter dated 1/10/2021, the defendant informed the present plaintiff that he was paying maintenance charge to the association as per order of the Honorable Court, and if the plaintiff was agreeable to take the responsibility of paying maintenance charges to the association, defendant was ready to pay the total rent to the present plaintiff. But I'll just pause here for a moment to correct the typographical error in the date. But in the video later dated 1st of October 2021, that will be read as 11. A few lines above.
Yes, 11/10/2021.
It should be 11. Blood.
Yes, 11/10/2021.
Blood. It is 1/10/2011.
1/10. It should be 11/10/2011.
Blood. The letter dated 1st of October 2011.
Okay, 1/10/2011.
Because that was prior to Milord, just after Milord, the flat was sold in 2011. Therefore, the letter was given contemporaneously. It is further averment of the defendant that plaintiff vide its letter dated 11/10/2012 invited the defendant to take inspection of the sale deed. Subsequently, Sudha Baid withdrew the suit being CS number 1 of 2004 from the Honorable High Court, Calcutta. The defendant has admitted that the defendant received a notice of ejectment dated 22/4/2013, and after receipt of the said notice, defendant tendered rent to the plaintiff by money order dated 5/6/2013, and after refusal by the plaintiff to receive the money order, defendant started to deposit the rent with the Office of the Rent Controller, Calcutta on and from May 2013 till August 2013, and that after appearing in the suit, the defendant filed application under Section 7(1) and 7(2) of the West Bengal Premises Tenancy Act and has been depositing rent regularly before this court. The defendant has denied that the plaintiff is the owner of the suit premises, and that the defendant has further denied that the premises was let out for residential purpose. Defendant has specifically stated that in the agreement for tenancy dated 15/5/1976, it was specifically mentioned that the said flat would be used for residential cum clinic purpose. Defendant has specifically stated that the defendant deposited the rent in the name of Sudha Baid till April 2013, and after withdrawal of the suit, defendant started depositing the rent in the name of the plaintiff at the office of the rent controller. From May 2013, defendant has denied that the plaintiff reasonably required the suit premises for his own use and occupation, and has denied that the plaintiff does not have any reasonable and suitable accommodation, and has further denied that there are 9 staff or employees under the plaintiff organization. Defendant has further denied that there are leave and license agreement between the plaintiff and other licensors, and that the leave and license agreement are manufactured for the purpose of the suit filed before the learned trial court. Defendant has denied that the residential accommodation is required to accommodate the manager and assistant manager of the plaintiff company, and has further stated that the defendant, Mrs. SN Alloys Private Limited, are involved in real estate business, and Arun Sancheti is one of the plaintiff, and he is also director of many other private limited companies, and that Arun Sancheti has a big office, being room number 503A on 5th floor at Shantiniketan building at 8 Kamak Street, Kolkata, and that Arun Sancheti is owner of 10B, 10C and 10D at Nilkant building, and flat number 10B and 10C are in the name of Arun Sancheti, and flat number 10D is in the name of Mrs. Sancheti Products. But this 10B, 10C, 10D are in the same building. And Lord, that is in another building, that is 8 Kamak Street, nearby.
So, by whom is this flat owned? 10B, 10C and 10D?
10D was, Lord, in course of Lord evidence, it was said, Lord, that has been, Lord, sold. So 10C and 10B and 10C was inspected.
10B and 10C was inspected.
10B was owned by Arun Sancheti,
Director.
and Lord, 10C was owned by his father.
Okay. But 10B was owned by Arun Sancheti.
10B is Arun Sancheti's.
And 10D was already sold.
According to them, their statement.
They have filed documents that they have already sold.
They have already deposed in the evidence. Defendant has further stated that the defendant
and
has
10D was in the name of this company.
Sancheti Products.
10D.
Which, Lord, there is Arun Sancheti is a common director.
Okay. Of the plaintiff company and this.
As well as, Lord, this holding companies or Lord, the other companies.
Yes.
The defendant has further stated that the defendant has not done any act in violation of clauses MOP of Section 108 of the Transfer of Property Act, and the defendant is not guilty of any waste and negligence. Therefore, the defendant prayed for dismissal of the suit with cost. Now, Lord, the issues have been, Lord, set out. I am not repeating, Lord, the issues before your Lordship. The points for consideration, Lord, it starts at, Lord, page 77. Lord, your Lordship may, Lord, kindly come to decision with reasons at page 78. But paragraph 8. On proper scanning of the evidence on record, I find that in ejectment suit number 270 of 2013, 2 witnesses have been examined by the plaintiff, while the defendant has examined only 1 witness. But these 2 witnesses, one is, Lord, the Arun Sancheti, PW1, the court-appointed commissioner is PW2, and DW1 is, Lord, my present client, the wife of, Lord, the erstwhile defendant. Both sides produced several documents which have been marked as exhibit. The plaintiff appellant herein has examined one Arun Kumar Sancheti, one of the directors of the plaintiff company, as PW1. The learned advocate commissioner Tinia Dash has examined herself as PW2, and documents were also placed on record which have been marked as
anyway,
exhibit.
suit property was not inspected by commissioner.
Yes.
This is the admitted position.
This is an admitted position. Marked as exhibit 1 to exhibit 24 by 1, which are as follows. But, the exhibit list has been, Lord, set out here. In his evidence in chief, Lord, at page 80, Lord, after, Lord, the exhibits, In his evidence in chief, PW1 has corroborated the plaintiff case. In his cross-examination, he stated that the other directors of the plaintiff company are his wife, Sunita Sancheti, and uncle Sampadmal Sancheti, and that the shareholders of the plaintiff company are members of his family and his uncle's family and others. He has stated that 7 or 8 private limited companies have their registered office at 8 Kamak Street, and that there are 3 or 4 companies where he or any member of his family are directors. He has admitted that he is director of Sancheti Enclave Private Limited, but he failed to state the names of the other companies where he or any of the members of his family are directors. He has admitted that the office accommodation of the plaintiff company at 8 Kamak Street was not inspected by the commissioner. Lord, this is the alternate accommodation of Lord the plaintiff.
So neither the suit property was inspected,
Not the alternative, not
nor
the
the
registered
alternative
office.
accommodation was inspected.
So this is not an admitted position. What were inspected were not 2 other flats in the other building, that is not Nilkant building. He has stated that the plaintiff company is involved in the business of finance and broking and steel, and he has stated that he is not aware of the existence of Mrs. Sancheti Estate Private Limited. He has further stated that Sancheti Project Private Limited is running 2 projects at Rajarhat. He has admitted that he is one of the directors of Mohabaleshwar Distributor, and he is one of the directors of Sancheti High Rise Private Limited, and that he is one of the directors of Ankita Housing Private Limited. He failed to recollect if he is director of Charnock Estate Private Limited. He failed to say if all these companies have their registered office at 8 Kamak Street or not. He has specifically stated that the plaintiff company purchased the suit property from Sudha Baid and stated that Mrs. Rosewood Merchant Private Limited was the confirming party in the deed of conveyance, Exhibit 1, and the registered office of Mrs. Rosewood Merchant Private Limited is at 8 Kamak Street. But I will explain this later on, because there is, I'll show the interlinking of how the transaction went. Who signed on behalf of Sudha Baid? Who confirmed it? And the company which confirmed the sale of 2011 was one of the person who issued the appointment letter to those 2 gentlemen, Navin Setia and Arun Baid. These are all on record. That Rosewood Merchant Private Limited was a confirming party in the deed of conveyance, Exhibit 1, and the registered office of such and such at 8 Kamak Street. He stated that he is not aware of the office of Mrs. Rosewood Merchant Private Limited is running analogously from the office of the plaintiff. He further stated the consideration amount was paid to Sudha Baid and the confirming party. In his further cross-examination, he has stated that the suit was filed on the ground of reasonable requirement of the plaintiff to accommodate Navin Kumar Setia and Arun Kumar Baid, 2 employees of the plaintiff company. He has filed their appointment letters signed by Prakash Sharma as director of the confirming party, that is Rosewood Merchant Private Limited, and that he has also issued money receipt. This is where the collusion comes in. Prakash Sharma is not issuing the appointment letter to Arun Kumar Baid and Navin Setia. He was the director of Rosewood Merchant, who was a confirming party in the sale deed. He has further stated that Navin Setia has signed as the constituted attorney of the vendor, Sudha Baid, and accepted the consideration amount on behalf of Sudha Baid. And he admitted that Navin Setia is the same person who had signed as the constituted attorney on the deed of conveyance and for whose accommodation the plaintiff has filed this suit. In his further cross-examination, he has stated that he and his father are the owners of flat number 10B and 10C, Nilkant building, and that flat number 10D was owned by Mrs. Sancheti Private Limited, and during the pendency of the suit, the said flat has been sold to one Binay Kumar Baid, one of the directors of Sancheti Projects Private Limited. He has admitted that in the tenancy agreement, Exhibit 9, it has been mentioned that the purpose of tenancy was for residential as well as for the purpose of doctor's clinic. He denied the suggestion that the plaintiff company was in possession of 3 flats, being flat number 10B, 10C, 10D at Nilkant building at the time of filing of the suit. He failed to say whether Sancheti Projects Private Limited and plaintiff company have a common directives. He has denied the suggestion that he is the exclusive owner of Sancheti Projects Private Limited and he was the owner of flat number 10D Nilkant building. Tinia Das, learned advocate commissioner, examined herself as PW2 and she stated in her examination in chief that she is the practicing advocate of this court. And after receiving read of this court, she had issued notices to both the parties and thereafter conducted inspection of the suit premises in the presence of both the parties. And subsequently, she filed report. In her cross-examination, she stated that she was directed to inspect flat number 10B and 10C at premises number 26 by B Kamak Street. Therefore, not only 10B and 10C was inspected. And she has stated that she inspected those rooms which were shown to her by the plaintiff. On the other hand, the defendant respondent has adduced evidence of one Chandrolekha Anand Sayo, the wife and constituted attorney of the defendant, as DW1. The documents filed on behalf of the defendant have been marked Exhibit A to Exhibit J are as follows. The exhibits have been set out. In her examination in chief, DW1 corroborated the written statement. In her cross-examination, she has stated that her husband used to supervise the suit, which was filed before the Honorable High Court. She has admitted that her husband, Mr. Texan Sayo, is a director by profession, and it should be not a doctor by profession, and it still is in practice, and that Mr. Texan Sayo conducts his chamber from the suit premises, and he is in Kolkata. She has denied the suggestion that her husband is physically fit. She has admitted that Sudha Boyd was the original landlady and that Sudha Boyd wrote a letter informing she has sold the property to SN Alloys Private Limited. She has further stated that she had deposited rent at the office of the rent controller in the name of the present plaintiff. She has further admitted SN Alloys and Sancheti Project Private Limited are different companies and flat number 10D stood in the name of Sancheti Projects Private Limited. In a further cross-examination, DW1 stated that the residential address of Naveen Setia has been mentioned as 8 Kamak Street, Shantiniketan Building, 5th floor, room number 3A. But she has admitted that the residential address and office address of Mr. Setia is the same, that is 8 Kamak Street. On proper scanning of the evidence on record conjoined with the reading of materials on record, it comes out that the appellant plaintiff had instituted the ejectment suit against the defendant on several grounds, that is default, reasonable requirement, change of mode of user, guilty of waste and or negligence, etc. under the West Bengal Premises Tenancy Act. The defendant respondent duly appeared in the ejectment suit to contest the same and file application under section 1 and 2 of the West Bengal Premises Tenancy Act, 7172 it should be, which have been duly disposed of and the ground of default was accordingly made clear.
So the original defendant tenant died during the pendency of second appeal.
Yes. Second appeal er সময় তো মারা গেল। হ্যাঁ, আমরা দেখা substitute yes. In the ejectment suit, the plaintiff appellant has alleged the defendant with change of mode of user and guilty of waste and or negligence, but in support of the same, the plaintiff appellant could not adduce any reliable evidence for which the learned trial court correctly decided the issues against the plaintiff appellant. According to the plaintiff company became the owner of the suit premises by purchasing the same for valuable consideration. From Shudabai, the suit premises is occupied by the defendant as a tenant from the previous owner, Srimati Shudabai. The defendant also admitted the same fact, that he is originally a tenant of the previous owner. The deed of conveyance dated 18/11/2011 executed between Srimati Shudabai and plaintiff company has been marked as Exhibit 1 in the suit, from which it comes out that the plaintiff company has purchased the suit property from the previous owner, Shudabai, upon payment of consideration money. In the appeal, the defendant has put question on the reliability of the deed of conveyance dated 18/11/2011 regarding the title of the appellant over the property. Learned advocate for the respondent defendant has argued that it was purchased on much lesser price than the market value and the address of the constituted attorney and the plaintiff company and the confirming party are same. And it was executed by the constituted attorney of Sudha Baid, for whose accommodation the ground of reasonable requirement is sought for by the plaintiff appellant. He has argued that the document was manufactured for the purpose of the present suit for eviction of the defendant tenant from the suit property. He has argued that though the document was marked as exhibit, but the probative value of the same carries no weight. In this regard, he has relied in the case of my lord such and such, that is a reported decision. Learned advocate of the plaintiff appellant has argued on the other hand that the respondent is a mere tenant under the appellant after purchase of the suit property from the previous owner, Srimati Sudha Bait, and therefore does not have any right to challenge the title of the appellant in respect of the suit property. He has submitted that the deed of conveyance executed by the vendor of the appellant in respect of the aforesaid flat in the suit property is a registered document, and the defendant respondent being a tenant cannot challenge the title over the suit property. It comes out from the record that Exhibit 1 is a sale deed between the previous owner Sudha Boyd and the plaintiff company dated 18/11/2011, and after the sale of the suit property, the previous owner Srimati Sudha Boyd issued a letter of atonement dated 17/1/2012 to the defendant, which has been produced by the plaintiff appellant in the ejectment suit and was marked as Exhibit 11. It was duly acknowledged by the defendant on 1st February 2012. The plaintiff has also produced Exhibit 12, that is letter of the defendant dated 1/10/2012, seeking inspection of the sale deed from the plaintiff. It comes out from Exhibit 13 that the plaintiff by letter dated 11/10/2012 invited the defendant to take inspection of the plaintiff's sale deed, that is the deed of conveyance dated 18/11/2011. Moreover, the plaintiff has filed document Exhibit 7 to show that the earlier suit of eviction filed by the previous owner, Srimati Sudha Boyd, bearing CS number 1 of 2004, had been withdrawn by her on 10/4/2013 with liberty to file a fresh suit, and only thereafter the plaintiff issued eviction notice dated 22/4/2013, Exhibit 20, upon the defendant. It comes out from the record that the ejectment suit was filed on 15/7/2013. Above all, it comes out from the evidence of DW1, Chandralekha Anansayo, that she had admitted in cross-examination that she has deposited rent in the name of present plaintiff appellant before the rent controller, which means she has admitted the landlord-tenant relationship between the plaintiff landlord and the defendant tenant. Moreover, the Honorable Supreme Court has been pleased to observe in plenty of cases that once the landlord-tenant relationship has been established between the parties, the tenant cannot challenge the title of the landlord over the suit property. It comes out that the main ground for filing the instant appeal against the judgment and order passed by the trial court is that the issue of reasonable requirement was also decided against the plaintiff appellant. Learned advocate for the plaintiff appellant has admitted that the plaintiff reasonably required the suit premises for providing residential accommodation to its senior staff, namely the manager and assistant manager of the plaintiff company. He has argued that despite having ownership of the suit property, the appellant has to incur huge amount every month toward the payment of rent for providing residential accommodation to its senior staff for rent for 11-month leave and license basis from the third parties. This fact has been narrated by the plaintiff in paragraph 12b of the plaint. In support of the contention, plaintiff appellant has adduced evidence as PW1 and produced documents like appointment letters of two senior staff, namely the manager and assistant manager, that is Naveen Setia and Arun Kumar Boyd, respectively. The salary receipt of Naveen Setia and Arun Kumar Boyd, Exhibit 19. 4 leave and license agreement, Exhibit 16. Rent receipt issued by the licensor to the appellant, Exhibit 17. The respondent defendant in the written statement denied the requirement of the appellant plaintiff. Learned advocate for the defendant has argued that to establish a case of eviction on the ground of reasonable requirement, the ownership upon the landlord to establish the same. He has relied on the case of such and such. Learned advocate for the respondent has argued that as the appellant deals with real estate business.
No, another thing is this, where so the managerial persons who were inducted into the company for whose accommodation the plaintiff sought eviction, were these persons residents of this Calcutta area or from outside area? Were they splitted?
Lord, we find that from the evidence that one of Lord this Naveen Setia, he has a residential Lord address written in his Lord identity card at 8 Kamak Street.
Oh yes, the question that is the persons, the managerial persons.
Lordship,
whether they are coming from Delhi, Bombay, so they require some residence here, or whether they are Calcutta or adjoining areas.
Lordship,
they are the residents. Were these facts pleaded before the court?
No. I understand my lord's query. That is Naveen Setia and Arun Boyd, where they originally lived. Whether they originally lived, whether they are from Calcutta or from outside Calcutta, so that they require accommodation.
Yes, so because you see sometimes house rent allowances are also given. Because at the time of induction, whether these facts were there before the trial court.
No, my lord, these were not there.
Because company,
Their
you see,
residential address were not, my lord. Yes, my lord, the appointment letter at page 61, my lord, that is not
appointment letter.
of Navin Setia.
Yes.
That is not Kolkata, 59 KC Ghosh Road, 59. Kolkata 50.
Letter. That is?
That is Navin Setia.
Yes.
And for Arun Boyd, Lord, I'll give you a lot, Lord, that. Yes, that is at page 64. Lord, that is 177 Mahatma Gandhi Road, Kolkata 17.
Navin Shetty and the other is?
Arun Kumar Baid. Arun Kumar Baid. 177 M full stop G full stop Road, Kolkata 17. Page 64 of Lord the part. It is part. Lord, that is not the respondents, Lord, the compilation of document. That is not the part 2 of the paper book, maybe.
Okay, that will be considered.
Lordship. The learned advocate for the respondent has argued that as the appellant deals with real estate business and is involved in promoting and selling flats, and so the appellant has alternative accommodation and does not require the suit premises. But the projects that are developed by the appellant plaintiff are for sale. That is the business of the appellant and not for personal consumption. Learned advocate for the appellant plaintiff has submitted that the plaintiff, being a limited company, is a separate juristic person having separate legal entity and can seek for its reasonable requirement under the Premises Tenancy Act, irrespective of promoting business. Therefore, buying, constructing, selling flat is one of the business of the plaintiff company which cannot be used to house its office staff. In the written statement, the defendant took a defense that the director of the plaintiff company, Sri Arun Kumar Sancheti, PW1, is the owner of flat number 10B and 10C at premises number 26B, Kamak Street, Kolkata 16. He has relied on the decision made in the case of such and such, where the Honorable Court has discussed the decision of the Honorable Supreme Court in the case of such and such, wherein it was observed by the Honorable Apex Court that in considering the bona fide requirement of the landlord, the court must take all relevant circumstances into consideration so that the protection afforded by law to the tenant is not rendered mere illusory or whittled down. Learned advocate for the appellant plaintiff has argued that Mr. Arun Kumar Sancheti is only one of the directors of the plaintiff company, and in any event, the residential accommodation available to one of the directors of the plaintiff company cannot be accounted for the plaintiff company. Director of the plaintiff company is a separate legal entity, whereas the plaintiff company is a separate legal entity. However, it comes out from the cross-examination of PW1 that he has specifically stated that he is the owner of flat number 10B, while his father, Mr. Sumermal Sancheti, is the owner of flat number 10C of the said premises, and those two flats are exclusively used for their respective residential purpose, and they are living there with their respective families. In support of this contention, commission of local inspection was held, and PW2...
So these two flats, the commission was held?
Yes. And the one is owned by Arun Sancheti and other by his father.
Okay.
Has deposed... in support of this contention, commission of local inspection was held, and PW2 Tinia Das, learned advocate commissioner, was deposed in the ejectment suit, and filed report and relevant document being Aadhaar card and voter card has been filed and exhibited, Exhibit 4 series and Exhibit 22. Therefore, those two flats are not owned by the plaintiff company. The defendant has also raised a point that flat number 10D was owned by Mrs. Sancheti Projects Private Limited, which was sold out during the pendency of the suit, and therefore there is no reasonable requirement by the plaintiff appellant. Learned advocate for the appellant plaintiff has submitted that Sancheti Project Private Limited and plaintiff company, namely SN Alloy Private Limited, are separate and distinct private limited companies having separate legal entity, and as such, the said flat number 10D cannot in any event be said to be in occupation of the plaintiff company, and as such, the question of local inspection does not arise at all. It comes out that during evidence, PW1 has admitted that he was director of the Sancheti Projects Private Limited also, and he has sold out the said flat to third parties. But a person can be director of several private limited companies as permitted under the Companies Act, and accordingly he can sell out a flat to of a separate company in a capacity of the director. It comes out from the record that the learned trial court has observed that the appellant plaintiff has an accommodation at 8 Kamak Street, Shakespeare Sharoni, Kolkata 17, but the appellant did not pray for inspection of the same, though it is the duty of the appellant to bring the true picture of the accommodation available to him. On proper scanning of the evidence and materials on record, both oral and documentary, it comes out that the plaintiff company has stated itself that it has its office at 8 Kamak Street, which is the business place of the appellant. Even in paragraph 19 of the written statement, it is specifically stated by the defendant that Mr. Arun Kumar Sancheti has a big office being room number 503A on the 5th floor of Shantiniketan building at 8 Kamak Street. The respondent defendant has specifically admitted in the written statement itself that the accommodation of the appellant plaintiff at 8 Kamak Street is of commercial nature and is being used as an office space for the group of companies of the appellant and or directors of the appellant. The defendant raised objection on the ground that Naveen Kumar Setia has used the address of 8 Kamak Street, Kolkata 17 as his residential address as exhibited in K1, K2, K3. Against such submission, the appellant plaintiff has submitted that the residential address has to be mandatorily given for the registration of the director's identification number. Since there is no permanent residential accommodation of the plaintiff's manager, Mr. Naveen Kumar Setia, and since he is residing in temporary places having 11 months license agreement of the plaintiff appellant with the licensor, therefore he has used the address of 8 Kamak Street as his residential address. During cross-examination, DW1 has admitted that the residential address and office address of Mr. Setia is same, that is 8 Kamak Street. Therefore, the defendant in his written statement as well as in his evidence has admitted that 8 Kamak Street is an office space used for commercial purpose only, and thus according to section 58 of the Evidence Act, admitted facts need not be proved. Moreover, for abundant caution, the appellant plaintiff has filed an application under Order 39 Rule 7 read with section 107 of CPC in the instant appeal to bring out the true picture that the said accommodation is purely commercial accommodation and is being used by the appellant exclusively in the office space. This application is to be disposed of along with the appeal. In view of my above observation, I must hold that it is not required anymore, as the fact is admitted by the defendant respondent, and thus this application is disposed accordingly. Similarly, the appellant themselves took out an application for inspection of 8 Kamak Street. The learned judge, Lord, in the appeal court said it is not required for the reasons stated here. In the ejectment suit, the plaintiff has prayed for eviction of the tenant defendant on the ground of reasonable requirement, as the plaintiff company has to provide rent-free residential accommodation to its senior staff, namely the manager and assistant manager, Mr. Naveen Kumar Setia and Arun Kumar Bhai. In this respect, he has filed appointment letters and salary receipt of the manager and assistant manager, Exhibit 15 collectively, Exhibit 19 series. It comes out from the record that the learned trial court has observed that there were requirement of the suit premises for the period 1st April 2013 to 13 September 2013 by the appellant, as the senior staff have been appointed on a probationary basis for 6 months. On consideration of the materials on record, I find that the appointment letters, Exhibit 15, collectively show that there would be an extension period of service at the discretion of the appellant. It comes out from Exhibit 15 collectively that the appointment letters contain the particulars of the salary and particulars of rent-free accommodation, and the terms and conditions attached to the appointment letter is only part of the same, which cannot be read separately. Learned advocate for the defendant respondent had argued that Naveen Kumar Setia, who was the constituted attorney of Sudha Baid, is the same person who was appointed as manager of the plaintiff company for whom the accommodation is required. It comes out from record that the deed of conveyance was executed between Sudha Baid and plaintiff company on 18/11/2011, and the appointment letter was issued to Naveen Kumar Setia by the plaintiff company on 3/4/2012, which is quite natural. Further, it comes out from the record that it is also indicated in the salary receipt, Exhibit 19 series of the manager and assistant manager, that the salary has been paid by the appellant plaintiff to the manager and assistant manager Naveen Setia and Arun Kumar Baid beyond the probation period of 30th September 2030. Moreover, there was no objection from the respondent on this point, nor there was any cross-examination in respect of the salary receipts. Therefore, the service of the manager and the assistant manager Navin Sethi and Arun Kumar Vaid are continuing one beyond its probation period, inasmuch as the residential accommodation have been provided to them by the appellant plaintiff. The learned trial judge has observed that though the appellant has produced 4 leave and license agreement, but those were not proved as per the provision of law. In this respect, the learned advocate for the appellant has submitted that the appellant plaintiff has filed affidavit in chief, and in para 21 to 25 of the same, the plaintiff appellant has adduced evidence in respect of 4 leave and license agreement and the rent receipt in respect of residential accommodation given by the respective licensors. On proper scrutiny of the same, it comes out that the appellant plaintiff has specifically stated as PW1 in evidence that the leave and license agreements have been duly signed by the licensors and the signature is known to the director of the appellant, who was one of the signatory of the said 4 deeds of leave and license. The director who adduced evidence in the suit is PW1 has categorically stated that those documents have been executed by the licensors in his presence and both of them signed in the said document in presence of both the parties, and that the director is acquainted with the signature of the licensors. Therefore, those documents have been proved in accordance with Section 47 of the Evidence Act from the 4 leave and license agreements, Exhibit 16 series and rent receipt Exhibit 17 issued by the licensor of the appellant. It comes out that the residential accommodations are being provided to the senior staff of the appellant, which are still continuing. Besides, the requirement of the suit property are for providing accommodation to the designated senior staff of the plaintiff company. It can be for anybody, whoever is in that post. Therefore, in my view of my above discussion, I am of considered opinion that the appellant plaintiff has been able to prove the grounds of its reasonable requirement of the suit property for which the defendant is to be evicted.
So you will conclude on the next day?
Kindly give me about an hour's time, Lord. I'll take your lordship, Lord, to the evidences and Lord, the documentary evidences on record.
Yes, record and order. Learned Mr. Mukherjee, learned advocate for the appellant, submits but could not conclude his submissions. Let this matter appear on 15 তারিখে দুটোর সময় আছে কিছু?
আর একটা মামলা কত তারিখে আছে মামলা?
15 তারিখে দুটোই আছে। কি সেকেন্ড অ্যাপিল?
Would it be at 12 o'clock on 15th?
15 তারিখে আর কি 3টের সময়? 15তে 3টেও আছে।
14 তারিখ প্রবলদার আছে।
এখানেই আছে।
তাই বলছি হবে না 14
15 তারিখে 3টের সময় নেই।
হবে না। তাহলে
14 তারিখে 3টের সময় let this matter appear on 14
আমাদের কটায় আছে এখানে? There's one matter. My matter is fixed at 2 p.m. here.
On
14th.
Okay,
At 3 p.m. on 14th.
So let it be on that day. No, your matter is fixed at 2 p.m.
3 p.m.
3 p.m.
on 14th.
So
2 p.m. আছে?
14 তারিখে দুটোর সময় আছে আর 3টের সময় কোনো ম্যাটার নেই। আচ্ছা, তাহলে এটা 3টের সময় দিয়ে দিন। 14/1/2026 at 3 p.m.
Lordship.
2 p.m. এ তো দুটো ম্যাটার আছে। তাহলে হবে কি করে? অন্যদিন
3টের সময় হবে তোরটা।
Anyway, try to conclude on that day.
Yes, but now that
at 2 p.m. possibly 2 matters are fixed on that day.
I take about 1 hour of time.
I think Lord,
with the judgments and everything.
Convenient.
Huh? তাহলে 15/1/2026.
No, I can't.
So I'm making it 15/1/2026 at 2 p.m.
But may it be on 14th, Lord. I'll
try to 14 তারিখে থাক 3টের সময়।
দেখা যাক।
আগেরটা করবেন এটা কর।
I'm grateful.
কালীঘাট নিয়ে যাবো।
Before I
appeals.
If,
Ah.
if time does not permit, no question of taking up.
Whether we shall
If time permits,
whether we shall be waiting or
if both sides are present, I'll take up after 3 p.m. also.
and also 3:30 court will rise.
Yes. If there is some urgent matters, after 3 p.m. I'll take it up. If both sides are present.
Grateful. ফাঁসিয়ে দিল তো
Admin item number 2 and 3.
Yes, I'm reading out the operative portion. Hence, this FMA 288 of 2025 along with COT 48 of 2025 stands disposed. Judgment and award dated 18th April 2024 passed by the learned Additional District Judge, 6th Court, Paschim Medinipur in MSC case number 206 of 2019 stands modified to the extent that the claimants, respondent number 1, 2, 3 and 4 are entitled to compensation of rupees 9,58,200 from the appellant National Insurance Company Limited along with interest at the rate of 4% per annum from date of filing of claim case till date of deposit. The appellant National Insurance Company shall deposit the excess sum to the award passed by the learned trial court, being rupees 2,44,200 along with interest at the rate of 4% per annum from the date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order.
Grateful, madam. 4%. 4%. My lord, till deposit today.
Yes, from the excess amount. Excess amount from the date of filing of the claim case till today.
And my lord, rate will be 4%. My lord, interest.
Yes, yes, whatever is there by the trial court that remains.
My lord.
Grateful, my lord.
My lord, direction may be given to the Registrar General to disburse the amount. My lord.
No, first let them deposit thereafter. Anyway, after deposit, you will be permitted to withdraw. That excess amount has to be deposited first.
What he's trying to say, my lord, that one line direction from my lord that after we deposit and after due compliance of all the formalities, Registrar General should disburse the amount in favor of the claimants. That one line order of my lord will help the claimants.
দিয়েছি ওখানে।
Yes, upon deposit being made, respondent number 1 to 4 claimants will be entitled to withdraw the entire awarded sum upon compliance of all necessary formalities.
My lord.
Grateful, my lord. Deeply obliged.
Otherwise, my lord, they will not be disbursed. My lord.
Okay.
For hearing item number 4.
Lordship, I appear for the appellant. I'm being led by Mr. Shoptangshu Basu. He's on legs in court number 30. Lordship, if it can be taken up at some other day.
Okay, not today.
Lordship, if it can be.
Let it remain in its position.
Lordship.
Yes.
Respond.
Lordship.
Anyway, let it retain its position. Okay. Not today.
Next week.
Next week. Lordship, let it be.
Next week. My lord, it will be written if it is fixed on next week.
Okay, not this week. Not this week.
Not this week.
The next week.
Next week.
Yes, next week.
Yes, Mr. My lord, I am just Mr. Basu's junior. He's, yeah.
Anyway, I made it not this week.
Yes, yes. Okay.
Appellant Insurance Company. I've given my written notes, my lord. I've given a copy.
Other side is not
Yes,
here.
yes, yes, he's here. Oh, I'm sorry.
I'm passing it over.
No.
Anyway, not today.
Not today. I'm sorry.
Six. 27.
27, I am for the appellant. Mr. Bonik is opposing me. Matlab, in this matter, what has happened, your lordships directed me to pay that 1 lakh rupees cost to them. But I did not find anybody filing Vakalatnama on behalf of the respondents.
Okay, I'm making it not today, come tomorrow.
But I have the checks, I'll hand it over in court.
Have a talk with him, I'm making it not
I had
today.
a talk, Matlab, I'll hand it over in court. Let it be not today, Matlab, tomorrow.
I'm just making it not today.
I'm grateful, Matlab.
28.
Yes, not today.
Not today.
I am appearing for the respondent claimants, your lordship.
I'm appearing on behalf of the Appellant Insurance Company, my lord. I've given my written notes.
Your written note.
Yes, yes. I've
Hearing is
already.
concluded.
No.
No, on my part, I have more or less finished my submissions.
To submit your written notes.
Yes, he has given me a copy.
I have already served the copy. This is my written note, your lordship. I have already served the copy.
I'll just 2 lines I'll say, my lord.
Short matter.
Just ek bar bole the, I have preferred the appeal. It's under 163A. The learned tribunal awarded a total sum of rupees 2,55,000 along with interest, my lord, 6% interest. I have preferred this appeal. My main ground is, my lord, that non-involvement. This FIR was lodged against this unknown vehicle after 4 months. And thereafter, my lord, subsequently, this alleged vehicle came into the picture.
It's a death case.
It's a death case.
See, this is my written notes of argument, your lordship.
In this case also, like in the case, like in item number 63, my lord, I'll pray before my lord to.
Oh, there is a counter case.
Yes, they have cross objection also. They have filed.
So how much is the amount fixed? That is under 163A.
Now after amendment,
Now 5 lakhs.
it is 5 lakh in death cases.
So if the case succeeds,
My lord.
If your case succeeds,
My
then no question of payment. On the other hand, if your case does not succeed, then the question comes regarding 5 lakh.
My lord. My lord.
Yes, record an order. Learned advocates for the parties are present. Are learned advocates. Let the written notes of arguments filed be kept with the record. As the hearing is concluded, let the matter be treated as CAB.
My lord.
This is your paper book. What is your written notes? You have filed.
I filed.
Okay.
I have also filed.
No, your one is this one.
Lordship, my case, your lordship, that
Okay, this is the appellant's one.
That is
my I have given.
ওই যে না ওনারটা ওই আমারটা ওইখানে আছে ঠিক আছে
আমারটা দিলাম
my lord has made this CAB. I'm grateful.
Got my written notes.
Yes, definitely.
So my case, your lordship, that the FIR GD was lost on the self-same day. Now GD was lost, your lordship, the victim was taken to the hospital. It was a RTA case. The victim was taken to the hospital. From hospital requisition made, the GD was started. Now after 4 months, the PM report was prepared.
Yes.
Then the copy of the PM report was sent to the GD was sent to the PS. Now, after getting that PM report, it was found that the reason for accident is RTA. So, your lordship, the FIR started by the police itself. So, on that basis, charge sheet submitted thereafter trial thereafter.
Anyway,
Now,
matter record
another thing, your lordship, the owner initially appeared and filed his written argument, written WS. In WS, the owner admitted.
Oh, you see, written insurance company is under 178 is entitled to take the plea of the owner.
But Owner was not cross-examined. Owner was not examined by the insurance company. Driver was not examined by the insurance company. Nothing.
Anyway, you see, 163, the moment the involvement is established,
Then
no question to
no
prove.
question.
Page 15, my lord, will just once see. Page 15 of of my paper book.
Anyway, what it is, please read
It
out.
says the OP number 1 owner was served and appeared and did not take any step and was proceeded ex parte.
Ex parte. But WS was there. In WS, owner admitted the accident. So it was in view of the
That is the
judgment
question. You
of
see,
the-
there will be a plea. It is a collusion between you and the owner. So 178, they have taken that plea.
So they have taken the plea. Then, Your Lordship, they ought to have examined the owner.
Anyway,
and the
that's a
judge.
different issue.
Yes, Your
I'm extremely grateful to
Okay.
my
But
lord.
even
Deeply
there's no
obliged.
such examination, no such cross-examination, no such suggestion to the claimant or the eyewitness that no such accident was occurred, that vehicle was not implicated on that day, and any other vehicle was
What
implicated.
is your ground of challenge? The quantum.
No, quantum 5 lakhs, Your Lordship. My cross is for 5 lakhs.
I'm grateful, my lord. Deeply obliged.
So I've given him all the judgments and with the.
Okay.
One humble prayer, my lord. My matters, my lord, will make not today. I leave then, not feeling very
Okay,
well.
you have still not recovered.
I
from your
had
illness.
I had fever yesterday, and there are other problems also I'm having. I'm on a lot of medication now.
Okay, not today.
So, my lord, grateful.
33, 34, 36 and 7, 38, 39, 40, 41, 42, 43 and 44, 45, 46.
45, 47, 46, 47. 46, 47, also make it possible, Mr. Sayanti Shad is appealing for the appellant. Just make it possible, just possible.
45, 46.
46, 47. The case already been decided, the ratio has been decided by the another coordinate bench, Lordship. But I will show the judgment and they are the appellant, whatever.
Okay, let it come. Let it be not today.
Lordship, make it short possible, just I am trying. But because of very short matter, I believe it could be disposed of by your Lordship today.
Okay.
Kindly make it short possible.
Okay, pass over.
48, 8 and 49, 50, 51, 52, 53, 56.
In the item matter, I am in the 53. I am appearing on behalf of the claimant. This is a railway matter, my lord. Today the case is fixed for hearing.
Yes, Lordship, I'm praying for 2 weeks adjournment.
53.
Yes, Lordship,
Okay.
I'm not
Let
prepared for
this-
the final.
Let this matter appear on 19/1/2026. 2 weeks time chaiche. Let this matter appear on 19/1/2026.
My lord, I have one humble submission. In this matter, no LCR is there in the record. Though I have all the certified.
Let the trial court records be called for.
Yes,
At the special messenger cost
my lord.
of the respondent.
Claimant.
No, you are the claimant.
I am for the claimant.
Okay, at the special messenger cost of the claimant appellant.
Yes, Your Honor. Grateful to your lordship. What date gel?
54, 55,
19/1.
19-1. Grateful,
56,
lordship.
57.
Yes, 56.
Lordship, kindly fix it on 20th. Lordship,
56.
Lordship, kindly fix the matter on 28th, 19th. Rest 53, item number 53. Kindly fix the matter, not 19th, on 20th, Lordship.
20.
20.
আচ্ছা 20 item number 20 ওটা 20 তারিখে করে দিন instead of 19.
Item number 53.
56 minute, I am for the claimant respondent.
You are for the claimant respondent.
Madam.
Anyway, not today. Other side is not here.
Yes, madam. She just informed me that
Yes.
she's suffering from fever and she.
57, I appear for the appellant, madam.
57, you are for the appellant. Who is for the Union of India?
Union of India, someone has appeared.
Trial court records have come.
My lord, dear, trial court record is not necessary. Let it be not today. Let me.
No, paper books have been filed.
Paper books has been filed, well, and entire trial court records has been incorporated through paper book, madam.
Okay, item 57, not this week.
Only not this week. Let it be not this week.
Not this week.
Not this week.
Inform the other side.
Deeply oppressed.
58 to 60.
58, Your Lordship, Mr. Singh's appeal. my learned friend, and I am in 59, my appeal, Your Lordship.
Yes, 58.
You petition.
না না আমিও তো রেসপন্ডেন্ট ওর অ্যাপিল
উনি আছেন এমপি দা আছেন আসছেন
কোথায় আছে 33 নম্বর আইটেম চলছে
No, 58, your appeal. You are for the respondent claimant.
I am for the respondent claimant, Your Lordship. I have filed one separate appeal, Your Lordship, for enhancement of the
And this cross of
award.
United Insurance.
the appeal is filed by New India Assurance Company Limited.
Milord, I'll just clarify. Milord, in 2 minutes time I'll clarify everything.
Huh? Paper books. Have you filed the paper books?
So I have one extra paper.
Anyway,
Relax.
No, appeal.
Milord, the paper book what is before your lordship not is filed by Mr. Shubir Banerjee. The top. Is this the one, Milord, what my lord has got?
Yes.
Right. Milord. It's consisting of, Milord, 97 pages.
Page 97.
Lordship,
That means
it
there is a
consists of
supplementary paper book.
It is supplementary, Milord?
No, this is up to page 43.
Then, Your Lordship, I am giving this copy, Your Lordship.
দেখে নিন ঠিক করে
এটা নিন এটা
Yes. So what is the
Milord,
facts of
one,
this?
Milord, I'll just indicate to your lordship, Milord, what is all about. Milord, one 52-year-old assistant sub-inspector of police, Milord, while going in a bus, Milord, was dashed by an oil tanker. He died. Milord, I am the insurance company of the bus. My learned friend is for the assistant sub-inspector of police, claimant.
The legal heirs.
The legal heirs, Milord, yes. And Milord, my other learned friend on the other end, Milord, is for the insurance company of the oil tanker. That is United India. Milord, learned tribunal judge, upon hearing, Milord, and taking evidence of everything, Milord, passed a principal award of rupees 42,70,000 with interest, Milord. This is a principal award. Both the insurance companies of both the vehicles, Milord, my client, the bus, New India, and Milord, the oil tanker, United India, they were asked to pay, Milord, 50% of the award each. That is 21 lakh odd, Milord. Both of them.
50% equally.
50% equally. It was equally proportionate between both the insurance companies. I understand, Milord, that United India, the oil tanker, they have paid their share of award. Milord, my client, the insurance company, New India, the insurer of the bus, has come up before your lordship, Milord, on the ground that there was no fault of the bus in the said accident. The entire fault, Milord, was of the oil tanker. Therefore, Milord, the liability, whatever it is assessed, it should be paid by the United India, the oil tanker.
Bandyopadhyay.
Milord, her ladyship, Milord, heard this matter.
No, if it is a part-heard matter, then it should go to that bench.
এখানে এই শুনানি ফার্স্ট টাইম হচ্ছে এখানে শুনানি
No, if the
but
matter
Milord,
was
part heard, Milord, it is not marked in on my brief.
It was not hard in part in that way.
Milord, part heard is not marked here. If it is part heard, it would be there in the record. If it is not, it is not.
It's not part hard.
তাহলে নেই তাহলে জিজ্ঞেস করছেন কেন মানে তাতে কি হয় Milord, what difference does it make, Milord? I don't understand. A hearing matter is a hearing matter.
If it is part-heard, it will
It is
be
not
recorded.
part heard. That's what I asked my lord's office. আছে কি আমার মনে হয় না তাহলে
Yes, only if it is a part-heard matter. it
yes,
should
your
go
lordship
to
is
the-
absolutely correct. My lord is absolutely correct. If it is part heard, Milord, it should go before her ladyship.
If it is not, then the Lordship is hearing it out for the first time. Yes, my Lord is. নেই তো দেখে নিন গন্ডগোল না
না পাঠাট নেই বলে তো ওখান থেকে বেরিয়ে গেছে
না উনি বলছেন পাঠার আছে Milord,
Yes.
So, Milord, that is the crux of the entire matter. My learned friend, Milord, on behalf of the claimant, Milord, he has filed a cross objection in my appeal. He has also filed a separate appeal, Milord. Points remain same. That is for enhancement. For enhancement. Whether it is a cross objection in my appeal or whether it is a separate appeal, it is for enhancement.
So
Milord,
United India Insurance Company has to contest this case.
United India Insurance Company has to contest this case against my client, Milord.
Yes.
Because I am saying that the entire liability was of the United India of the oil tanker.
Contest this case against your appeal also.
Against my appeal also. And Milord, and I shall be, Milord, meeting the arguments of my learned friend claimant on the point, Milord, that the enhancement, whether it is...
You argue your case, thereafter
yes,
with regard to the quantum,
Yes, yes.
he will submit.
Lordship.
No, cross objection is with regard to your appeal.
My appeal, Milord. Milord, the point in the cross objection, the grounds
And
as
the
well
separate
as...
appeal is same.
Same. It's for enhancement, Milord. Milord, my learned friend says, Milord, on behalf of the claimant, that the yearly income was not assessed properly, Milord. It should be a little more than what has been taken note of by learned tribunal judge.
Yes. What are the grounds of your challenge?
Milord, my ground in memorandum.
Yes, yes.
Milord, my point, Milord, I'll take a Lordship. Milord, start from the written complaint. I'll start from there. Milord, the point, Milord, as I said, Milord, I say the entire responsibility of negligence of Milord rash driving was of the oil tanker. That is United India. That is why, Milord, the liability should be of the United India. Though both vehicles were involved, but the liability, Milord, should be the...
The plea of contributory negligence is not taken.
Milord, it is not a case of contributory negligence. Contributory negligence, your Lordship knows, Milord, when the victim himself contributes.
Whether there was
It is a composite negligence.
either of the insurance company took a plea
Yes,
of
yes,
any
yes,
this contributory
Yes,
negligence.
Milord, your Lordship will kindly pardon me, Milord. Milord, these are contributory negligence and composite negligence. These are two different factors. Milord, contributory negligence arises in a case when victim himself contributes in the accident. In this case, this is not a case of contributory negligence because victim has not contributed to the
Either
accident.
composite negligence or
A sole negligence.
sole negligence.
Extremely grateful to your Lordship. But that's the point. Milord, first of all, Milord, Milord, the case starts, Milord. I'm sorry.
Yes.
Milord, this is the accident of 2019, 30th November, 30.
Yes.
Milord, 30th November 2019, that was the date of accident. Milord, I would invite, Milord, first of all, your Lordship, Milord, to page number 56. That is the written complaint from where the case is started. Your Lordship will kindly come to page 56. Is my Lord there, Milord?
Yes.
Ami Iqbal Asif, boys so and so. Milord, this was lost, Milord, on the very next date of accident.
Yes.
আমি ইকবাল আসিফ বয়স এত বছর পিতাই ঠিকানায় আনুমানিক ভোর 5:15 নাগাদ প্রতিদিনের ন্যায় আমি যখন প্রাতঃভ্রমণ করতে বাড়ির বাইরে আমি ঠিক সেই সময় আমার বাড়ির সামনে NS 34 এর উপরে শিলিগুড়ি থেকে বহরমপুরগামী একটি বাসকে যার নম্বর WP7. Milord, the bus by the New India, that is my client, বহরমপুর দিক থেকে মালদার দিকে রং লেনে যাওয়া একটি ডিজেল ট্যাঙ্কার যার নম্বর 7 বাসটিকে মুখোমুখি ধাক্কা মারে। যা ধরুন ডিজেল ট্যাঙ্কারের ড্রাইভার বাসের কন্ডাক্টর সহ আরো 2 জন বাসের যাত্রী মোট 4 জন রকম আহত হয়। Milord, this starts from here. Milord, the very first information which comes on record Lord, it states that tanker was coming in the wrong lane.
Which driver has been charged?
My lord, both drivers died,
Both the drivers died.
Lordship. So the question of drivers being charge sheeted does not arise here. Rather, charge sheet was filed, my lord, against one of the officers of the National Highway Authority. My lord, they said that, my lord, this when the diversion route was fixed on the road, my lord, this road was diverted. The repair work was going on. So, my lord, the police, upon proper investigation, my lord, it said that one of the diversion poles, my lord, or the signals were not put in properly. So both the drivers died, my lord. So the question of charge sheet against drivers does not arise. But
No, the case was instituted against both the driver. Oh, no question of.
no question of, my lord, this is, my lord, no question of drivers being involved here because both of them died. तुम बैठो क्या बोलो
Your Lordship, in the charge sheet, it is discussed that the driver of the oil tanker was responsible. Since the driver died, that's why the charge sheet against
That means
him not
case
filed.
was not instituted against the your client's driver. That means.
My lord, I'll show every single thing. My lord, whatever is coming to your lordship's mind. My lord, I had indicated, my lord, the first written complaint immediately after the accident. This one, it showed, my lord, the diesel tanker was in the wrong lane. It was responsible. From where the case started. The question which was posed by your lordship, my lord, what about charge sheet? About the drivers. Both drivers died, my lord. So the question of any drivers being charge sheeted, it doesn't arise here, my lord. But thereon, my lord, I'll invite your lordship, my lord, to the next part, that is the charge sheet. What does charge sheet say? My lord, I'll my lord, request my lord to come to page number 79. It's a part of charge sheet, my lord. My lord, charge sheet or the final form starts from page 71. My lord, I was praying before your lordship, my lord, to come to page 79.
Yes.
Is my lord there, my lord? My lord, last but one paragraph. Again, it is to be stated that during investigation, is my lord there, my lord?
Yes, yes, yes.
It is proved that for the impassive duty of NS34 authority, the signage system was not installed properly, and this is one of the main reasons of the accident. From Ballarpur to Gholakandi, the signage system is not properly installed. As a result, some drivers inadvertently used to go through the wrong lane. The photographer took some photos of Gholakandi Mode, from where it is clear that the NS34 authority didn't install the division sign at Gholakandi Mode. So I served notice to the safety officer, that is Mr. So-and-so of this area of NS34, and he appeared before me. That is National Airport Authority officer. And then we note the important part, last paragraph. However, during investigation, it has been learned that the driver of the oil tanker, namely Sonu Kumar Roy, was driving so excessive speed that he could not move for the left way and was moving through wrong lane. The accident took place due to rash and negligent driving of the driver of the oil tanker, who died on that day.
Yes.
So this is the conclusive part, Millet. Hence, prima facie charges of so-and-so has well been established against the accused driver, namely Sonu Kumar Roy, but not sent up him in charge sheet since he died. This makes, my lord, it absolutely clear.
Yes.
Now, my lord, the evidence part. My lord, prior to that, I would also invite your lordship, my lord, to the written statement of New India of my client. My lord, it starts at page number 5. My lord will kindly come to page number 6.
Yes.
Is my lord page number 6, my lord? My lord, one particular paragraph, that is paragraph 14, 1-4.
Yes.
My lord, the alleged name of the, my lord, it should be, my lord, the reason. The alleged name of the deceased was absolute negligence of vehicle number BR01GH5651 at the time of accident. My lord, this is the oil tank. There is no negligence of vehicle bearing number WB73A3697. This is my client, my lord. Bus.
Alleged death of the deceased.
My lord, death of the, it should be, my lord. There's one word typographical error. Otherwise, my lord, it's absolutely clear. The absolute negligence on the part of the oil tanker number this, and there is no negligence of the bus number this. The accident took place because of the rash and negligent driving on the part of the oil tanker. So, in my written statement, the specific pleading is there. So, I have taken your lordship, my lord, to the first information report, that is written complaint, the charge sheet, as well as, my lord, the written statement on behalf of the insurance company.
Yes.
The appellant before your lordship. My lord, the next part which comes in here, what is the evidence? My lord, there were 3 witnesses before the learned tribunal judge. My lord, the first witness,
Page.
my lord, first witness is page number 9, my lord, is the widow of the deceased.
Yes.
My lord, widow of the deceased was not an eyewitness.
Yes.
So, my lord, I am not giving, my lord, any credence to her statement with regard to the mode and manner of accident. She was not there. And the one who was there, my lord, the eyewitness, my lord, I'll straightway come to that rather, my lord, to show your lordship. My lord, widow was at page number 9. My lord, page number 14, my lord, is the next witness, is the sub-inspector of the police. Page 14.
Yes.
My lord, I would just, my lord, to indicate to your lordship, page number 13, my lord, the widow, what she stated. If my lord will kindly come to page 1313, in the cross-exam. My lord is there, my lord, page 13.
Page 13. Yes.
My lord, just to indicate that since she was not there, my lord, last 5th line or 6th line, it is not possible for me. Is my lord there? My lord, lordship has seen that. It is not possible for me to say whether there was any negligence on the part of the oil tanker only for the occurrence of the accident. My lord, she is not aware. It is not possible for her to say. So she has been very candid, my lord. She cannot say. So, my lord, this statement, or my lord, this witness does not carry.
She stated that it is not possible.
It is not possible because she was not there, my lord. So how can she say? My lord, next evidence, my lord, was of the sub-inspector of police. Page number 14 it is.
Yes.
My lord, this gentleman, my lord, had come up only to prove, my lord, the income and the vocation of the victim. That victim was the ASI of police and this was his salary. Lord, I'll come to this part as far as where I'll deal with the quantum, my lord. So this also does not, my lord, show any light or throw any light on the way the accident took place.
Yes.
My lord, now, my lord, the most important part, that is page number 16, PW3, the eyewitness to the accident.
Yes.
My lord, he was a co-passenger of the bus. My lord, in the first page 16, my lord, he says that yes, I was there. He rather says, my lord, in one particular sentence, I must indicate, my lord, in the paragraph 2, that both the drivers were negligent and responsible for the accident. It is against me. My lord has seen that, my lord, paragraph 2, that both the drivers. But now, my lord, in cross-examination, and I'll show that to your lordship. That is at page number 17. Specific, my lord, the answers are there. My lord, page 17 starts, my lord, examination in chief of PW3, my lord, and thereafter cross-examination. My lord, cross-examination is done by, my lord, by my client, New India. My lord has seen that, my lord. But may I just read? I came to court today to depose on the request of the petitioner. My lord, he is not my witness. It is the independent eyewitness. It is a fact that I boarded on the concerned bus in the night of 29:30 at Durgapur for going to Bahrampur. I took ticket. The petitioner was not present in the bus on that day. I did not disclose the entire fact to anyone before these days. I am a driver by profession. Your lordship will take a mark of this, my lord. He himself is a driver by profession. So, my lord, he would be knowing that what speed the cars or the buses or the vehicles are moving. He is having some idea how to drive a vehicle on road because he himself is a driver. That's what he said. I drive private light motor vehicles. I have my own driving license. Any vehicle used to be under control while it is running in between 40 to 50 kilometers per hour. My lord, he says that, my lord, if the vehicle is running between 40 to 50 kilometers, it would be under control. My lord, next paragraph. About 1.5 hours had been taken on the day to reach Malda by the concerned bus. The bus took a stoppage of Ranihati More, Malda at 1 p.m. in the night. Few passengers boarded. The bus started running thereafter. I reached Farakka at 2:15. Accident caused about half an hour after leaving Farakka. I was in the bus at the time of accident. He was there, my lord, in the bus. I was sitting nearest seat of it. It is not possible for me to say whether NS-34 was under construction or not. I did not sustain injury, but I accompanied the injured to the hospital. And then your lordship will kindly see, I know the number of the concerned bus. The bus was running in normal speed.
The bus in which he was traveling.
Yes, the bus in which he was traveling, the bus in which the victim was traveling. He said the bus was running in normal speed and then says, it is a fact that offending truck dashed the bus from its front in high speed by coming from the opposite side. What else remains from it? There was a diversion situated just behind the spot of the accident. It is not possible for me to say whether there was any signal for alerting the diversion or not. The accident, your lordship will kindly see again, Milad, the accident might not have happened if the driver of the truck drove the truck cautiously in normal speed. Reiterated, my lord, second time. The bus was blue and sky in color. The number of bus was, my lord, at page 18. The number of bus was written. Bus driver also sustained injury. At that time, I was going to Behrampur. I did not know the petitioner and his family. I came to know the petitioner through the elder sister. Then, my lord, your lordship will kindly see the clinching part. Cross-examination of United India. Is my lord there, my lord?
Yes.
This is, my lord, the tanker.
Whatever you have cross-examined, that is adopted.
So he accepts
that the rash and negligence of the tanker.
Tanker, absolute. Not even one question that why you are saying that the tanker was responsible. It simply adopts the entire submission made by, my lord, this eyewitness. It's an absolute and complete admission.
So the evidence was not adduced by New India Assurance Company, United India.
United, no, my lord, they have adopted, my lord, my cross-examination in toto. So, my lord, starting from written complaint, charge sheet, written statement of my client, and evidence. My lord, my case, my lord, I do not need to show anything else that why, my lord, why my client should not be, my lord, asked to make any payment.
Now let us come to the judgment.
My lord, the award of learned tribunal, my lord, starts at page 19 of my lord's paperwork.
Yes.
My lord, your lordship, my lord, I will only, my lord, indicate the relevant parts, my lord. Otherwise, my lord, it's a very lengthy judgment. If my lord so desires, my lord, I'll read it in its entirety. Otherwise, my lord, I'll read to the relevant part so that it becomes easier to your lordship, my lord.
So
Wherein, my lord,
page 20 is a bit illegible.
My lord, page 20 is illegible, my lord, but it doesn't deal with regard to the rash and negligent part. My lord, I'll just indicate where, because, my lord, we are on the issue of rash and negligent part. So, my lord, I'll not trouble your lordship with the other parts, driving license,
of the
negligence of the United India.
Of the vehicles.
Yes,
two vehicles.
Involvement of the vehicles. My lord, the facts and the evidence and the pleadings, I have shown it to your lordship. If my lord kindly comes to my lord, page number 23. My lord, paragraph 2020.
Yes.
On receipt of notice, yes, my lord, there, my lord. Perhaps, my lord, it is a little difficult for your lordship, my lord, because it is a little eligible, my lord. The type,
para 20.
Para 20, my lord. On receipt of notice, the opposite party insurance company, that is New India, my client, my lord, appeared before this tribunal by filing wakalatnama, filed written statement, and denied all the materials allegation of the petitioner. This is there, my lord. It has been taken note of. My lord, the last 3 lines of this paragraph. Your lordship will kindly skip, my lord, come to the last 3 lines. It is alleged. Is my lord there, my lord? It is alleged in the written statement that the entire incident took place due to negligence of the driver of the truck being number so and so.
Oil tanker.
Oil tanker. That is truck oil tanker. My lord, mine is bus. that the truck oil tanker being number BR so and so by filing the written statement of the insurance company, praying for dismissal of the instant amnesty case against my client. So, my lord, it has been taken note of. My written statements pleading. Learned Tribunal Judge Milord has taken note of this fact and recorded in its award that yes, I have taken the plea that my client bus is not responsible. The fault is only of the oil tanker or truck, whatever it is called, of United India. Milord, Lordship will kindly come, Milord, to page number 27. Running page 27. Milord, what is United India saying in their defense?
Written statement was filed by both the insurance companies.
Milord, the written statement of United India, Milord, it is not here as a part of this paper book, but they might have, they might not have, but the what Learned Tribunal Judge records here. I'll indicate that part.
It is not incorporated in
Milord,
the
it is
paper
not
book.
incorporated here.
No, in the other appeal filed by you, it is incorporated.
I haven't got the copy of that written up.
Anyway.
Irrespective of that, Milord, but their statement is recorded here in this award. Yes. That is what, Milord, I was indicating to your Lordship, Milord. Kindly come to page 27, Milord, paragraph 31. Is Milord there?
Para 31.
31, page 27.
Yes. It is argued.
I'm grateful to your Lordship, Milord. It's argued that the alleged truck being number so and so, that is United India, had come through the wrong lane of the road. Milord, this is argument made, Milord. It is argued that the alleged truck being number so and so had come through the wrong lane of the road, which caused the accident, and the bus had ran through its right lane. Therefore, the bus number so and so did not commit any negligence for which the insurance company of the bus cannot be made liable. So, Milord, the truck was coming from the wrong lane. This is what, Milord, the charge sheet also says. This is what the National Air Authority is also there. This is what the FIR is also there. This is what the evidence is also there. This is also recorded here, Milord, before in the Learned Tribunal's award. Milord, paragraph 32. It is further argued that the charge sheet of the Farakka PS case number so and so, the driver of the bus being number so, was not made as an accused. For negligent driving, but in the FIR, the driver of the truck number so and so was made as an accused of the accident on negligent driving. Milord, I have shown to your Lordship that part of the charge sheet which says that the accused driver is of the truck or the tanker. But since he died, Milord, so Milord, the charge sheet cannot be filed against him. Milord, Lordship will thereafter kindly, Milord, come to page number 31, 31.
Yes.
Milord, why the award was distributed between both the insurance companies? Your Lordship wanted to know this reason, that if it is so clear, then why? Milord, the very first paragraph is starting from the word here. Here in this case, there is no pleading on the part of both the insurance companies that there was contribution of either of the offending vehicles to the accident. Milord, this finding is wrong. Milord, I have pleaded, I have given evidence, the records are there that my bus is not responsible. Learned Tribunal just says that no, there is nothing on the part of the companies that which is responsible or the other one is responsible. Furthermore, here in this case, there is nothing in the pleading that the vehicle victim had contributed. Milord, I am not on victim's contribution. I do not say victim had contributed. Why is this finding here, Milord? It is absolutely, Milord, irresponsible finding, Milord.
Any discussion with regard to the written statement of the United India Insurance Company?
Milord, I do not find it. May be there. I subject to correction, Milord. Subject to correction. If it is there, Milord, my learned friend would show it. Paragraph you are saying, Milord, page 31. For paragraph 48. Milord, immediately I was coming there also.
There is no such pleading.
There is no such pleading by United India Insurance Company to the effect that bus, due to the improper signage system of the authority, the driver of the truck being number so and so had taken the wrong lane without any negligence. Thus, the contention cannot be taken in the favor of the United India. Milord, they do not even say that it is because of the wrong signage I was mistaken or I went to the wrong lane. Because, Milord, they went to the wrong lane. They were in excessive speed. These two factors are confirmed. But you should come up and say that, yeah, this was not my fault. It was because of the wrong signage. That also has to be there on their part. To deny that, yes, to deny that the entire negligence was not theirs. That is missing. This is what here has been recorded, my lord. And then, my lord, by virtue of this first paragraph of, my lord, page number 31 here, where learned tribunal judge just said that nobody is saying about the fault of other, which is wrong recording. My lord, your lordship will kindly see the last paragraph, last but one, again, starting from here, page 31 only, my lord, last but one paragraph. Here, in the case, as eyewitness, an eyewitness was examined by the petitioner, but the insurance companies did not adduce any witness on their behalf. There was no possibility of examination of both the drivers of the vehicles, as both of them had died. Lord, it says that
para 48.
Milord, para 50 last part.
50,
Milord,
yes, yes.
Milord, para 50 second part. Here in this case, Milord, the learned tribunal says insurance company did not bring any other witness. Milord, if the eyewitness is there, if I do not require to bring any other witness, if the case is crystal clear, then why should it be held against me that you are not bringing any other witness? Why shall I? Where is the law, my lord? I put this question to myself. Therefore, my lord, thus, your lordship will kindly see the last paragraph. Thus, the spirit of the said observation of the Honorable High Court, Calcutta, is that it is not essential for the claimant to examine the eyewitness. Considering, next page, my lord, considering all, I am of the view that the petitioners have been able to prove issue number 2, 3, and 4 in their favor, to the effect that on the said date, time, and place, same rash and negligent driving of the vehicle, the truck and bus causing the accident. My lord, how come this finding? I put this question to myself. What wrong have I committed? I did everything, and the court says, therefore, both the drivers are responsible. My lord, what more am I supposed to do in law?
It's not a simple head-on collision, but head-on collision for coming to the wrong track.
Yes, and in excessive speed. Because the eyewitness is himself a driver of some other vehicle. He knows what a normal speed is. Police says that the truck or the tanker was in excessive speed. Had he been alive, he would have been charge sheeted. They have said so, my lord. I have read that particular paragraph.
No, charge sheet submitted but not sent up.
Because he died.
Right, right.
So, my lord, then the paragraph 52 is the final paragraph. So, both insurance companies, United of the truck tanker and New India of the bus, are liable to pay the amount of compensation in 50-50. This is where, my lord, the matter ends.
Yes.
So, my lord, I humbly beseech your lordship, my lord, that the compensation amount, which has been, my lord, equally distributed between both these companies, should, my lord, be paid entirely by the United India. My client does not have any fault, my lord. Entire gamut of evidence, everything on record, including the finding of police, the eyewitness, the FIR maker, and, my lord, the admission on the part of United India itself while adopting, my lord, my cross-examination, which says that, yes, United India is solely responsible. They have said, yes, we adopted
The
that.
offending vehicle, of which the United India Insurance Company is the insurer,
Yes,
was fully responsible.
yes, they adopt my cross, which says that, yes, United India is responsible. They said yes. Nothing else is required to be proved in this case, my lord. My lord, this is my entire case as far as.
So, for the written statement of United India Insurance Company is concerned,
My lord, even assuming it is there, I take it for granted it is there.
they have denied the entire liability.
I take it they have denied. Then you come to evidence. My lord, hypothetically, even if I assume that, yes, they have denied, but they have, it is their own admission that, yes, they were in the wrong lane. You did not see the signage. If you say, my lord, we all drive vehicles, we all go on highways. If my lord, some repair work is going on, I take the diversion and I take the wrong lane. Wrong lane means, my lord, with the lane which is not made for me, it is only for the other side vehicle. My lord, I would be 100 times more careful. I'm taking the wrong lane. This lane is not for me. It is only because of the diversion. I should be careful because from the other end, they are not on diversion road. They are on their right track. They would be coming with full speed. I should always be more and more and more careful because I am taking the wrong lane. I am on the wrong lane. I blame diversion. Signage is not proper.
Because the moment and something takes place, any
Yes.
mishap,
Yes.
for any vehicle coming to the wrong lane,
Lordship.
of that
That
running
particular vehicle will be held responsible.
then definitely, you see, even if the other vehicle comes in a
Yes.
rash and driving negligently,
Lordship.
there is a contributory.
There will be composite negligence. Composite.
No, for example, one vehicle comes from the wrong direction,
Yes.
from the wrong track,
Yes.
and mishap takes place inside of a passenger who is inside the said vehicle
Lordship.
Okay. by another vehicle which is coming in the right direction.
Yes.
That was in a high speed.
Yes. Yes. That may be because they are coming in the proper way.
But although even if it is high
Even
speed,
if it is highway, yes.
there will be a more contributory negligence.
There will be more contributing negligence. Milord, that is why I'm in a much stronger footing. First of all, I say why? Because I was in the right lane. I was in the normal speed. I could have gone on an excessive speed because I was in the right lane. I did not do so. I was on the right speed. United India's tanker or truck, it went to the wrong lane and it was in excessive speed. So, Milord, what further evidence is required to be given to your lordship? And all these are proven facts. Milord, this was with regard to Milord, the shifting of Milord. That is why I say, Milord, 50% they have paid, Milord, they have accepted their liability. The balance 50%, which is, Milord, upon my client, that, Milord, that they should be directed to make payment. And my client, Milord, in this
if
case,
they can't satisfy.
if they can't satisfy, Milord, in this case, at least, Milord, my client does not have any responsibility. Milord, this is the first part of the rash and negligent driving. Now, Milord, I deal with, Milord, this, my learned friend's
Now, suppose
appeal.
you lose your case, for argument's sake, suppose you lose your case, then the question of quantum of compensation comes.
Goes, Milord, if I lose, then quantum of compensation
Quantum
comes in.
compensation
And if I succeed, Milord, then I would be arguing on behalf of my learned senior friend, United India, with regard to the quantum.
Okay.
Because he has, my learned friend for the claimant, has also prayed before your lordship, Milord, for increase in the quantum of compensation. Milord, shall I, Milord, I humbly, Milord, beseech your lordship, Milord, shall I argue on the point of quantum now or let them finish and then I'll argue the quantum
Because
point?
you are zoning your liability.
Milord, I want absolute exoneration.
Because if you do not have any liability,
Lordship.
there is no scope to
Extremely grateful to my lord. Extremely. Then, Milord, if I argue on quantum.
But you have to keep that option open because you don't know whether the case will go in your favor.
My lord, my
or
lord,
go
my lord,
against
my lord.
you.
This is why, Milord, I was beseeching your lordship, Milord, shall I argue on quantum now?
Will you submit?
I submit, Milord. Grateful to your lordship.
Yes. Because that liability is still on your head.
Lordship.
Yes.
If I win, then I would be helping my learned friend of United India.
Because 50% you have already deposited, the
I've
liability
deposited
is
for your
still on your head.
Yes. Milord, my learned friend on behalf of the claimant, Milord, has made out a case that the monthly income of the victim, this ASI, was not taken in the right perspective. It should be more. Milord, he has filed, exhibited, Milord, 2 salary slips.
Yes.
Milord, he has filed 2 salary slips
Yes.
before the learned tribunal, Milord, to prove the income of the victim.
Yes.
Milord, those salary slips, Milord, are annexed at page number 93 and 94 of my lord's paper book. 93 and the last but one, Milord, the 2 pages.
Yes, 93.
93 and 94.
Yes.
Milord, these are the salary slips, 2 exhibits.
Yes.
Now, Milord, these have been proved, Milord, as I have stated before your lordship earlier, by, Milord, one sub-inspector of police who was PW2. If I, Milord, first show that evidence and then come to your lordship, Milord, then it would be easier for my lord, Milord. Milord, page number 14 was the evidence to prove the income.
Yes.
Is my lord at page 14, Milord?
Yes.
Milord, the very last but one sentence. Milord, at the bottom, your lordship will see Last second, my lord, cross-examination. Cross-examination of PW2 by United India, taken on so and so with regard to the income, my lord.
Deemed to be declined.
No, my lord, just above that.
No, okay, your.
Above that, my lord. No, my lord, United Indians. The pay of salary is paid through IFMS system directly to the bank account. Is my lord there?
Yes, yes.
The gross monthly income of the deceased is rupees 41,663. 41,663.
Right.
This is what, my lord, the officer of the, my lord, police came up and stated before the court. My lord, before that, the widow also stated something about the salary. I'll indicate that also, my lord, and then your lordship will find, my lord, what is correct.
PW1.
Yes, my lord. My lord, what I had shown that was PW2.
Yes.
That was 41,663 gross.
Yes.
PW1, my lord correctly said, my lord, I'm grateful to your lordship. Yes. At page number 9, the very last sentence.
Yes. 44,500.
44,500. This is what the gross, she said. Monthly salary. So my lord has got two figures, 44,500 and this 663.
Yes.
My lord, what learned tribunal did? Learned tribunal, my lord, the award had started at page 19. At page 34, if kindly, my lord, comes to page 34, yes. Paragraph 69.
Yes.
Is my lord there? My lord, this is where the computation starts. The deceased had drawn, is my lord there? 41,663 per month as gross salary for the month of October, as PW2 has stated. 2019 and November 2019. He died on November 2019. It is proved that the pay slips for the month of October and November, which had been marked as Exhibit 15 and 16, are shown to your lordship. Respectively, both the pay slips were approved by PW2. Thus, the gross salary of the deceased was 41,663. After deducting professional tax of 200 rupees, it comes to 41,663 minus 200 is equal to 42,463. It should be 41,463. Typographical error because calculation was made on the basis of 41,463 correctly. 41,463. So, this is absolutely correct in terms of the evidence given by the police officer. My learned friend is unhappy. He says that no.
Future prospect taken into
consideration. Yes. Everything else is correct. Everything else is correct. My learned friend is unhappy. He says that no. 41,463, what was given in evidence, what has been taken by the learned tribunal is incorrect figure. He says, coming to page number 93, what I had shown to your lordship.
Yes.
My lord, the type space is a little smaller, my lord. I hope, my lord, I would be able to convince your lordship.
Page 93.
Page 93. My lord, 93 and 94 are same.
Yes.
My lord, the first column, my lord, this is for in the middle, your lordship will see is October 2019.
Yes.
My lord, the first column, my lord, is with regard to the, my lord, the heads, items. BP, DA, GP, so and so. And against that, my lord, the earning is given.
Yes.
My lord, this earning is, your lordship will see the total of the earning is 41,663.
Yes.
And then, my lord, this cumulative, we are not on cumulative since we are on the monthly basis, my lord. So 41,663 is the total what he was getting.
41,663.
Yes.
Yes.
This is what the total he was entitled to. And then, my lord,
deducting profession tax.
My lord, I'll show that. I'll come to that. No, 41,663 is inclusive of everything. Okay. Then deductions comes in. My lord, thus from this 41,663, my lord, what was deducted? Your lordship sees, my lord, deductions are, my lord, GIS, GS, GPF, and professional tax 200. Total deduction was 10,240.
Yes.
Am I correct, your lordship? I mean, this after this total deduction of 10,240, your lordship will see, my lord, at the bottom net pay 31,000, right?
Yes.
My lord, my learned friend says that these deductions are not permissible. my lord, provident fund, and my lord, this these are not permissible. I know that.
Proceeded on 41,463.
Lordship,
He
he
proceeded on that.
and he says that no, these deductions are again to be added on 41. I said that how can it be? His gross was 41. From that 41, this 10,000 was deducted. And then your lordship will see at the bottom, what is the net pay? 31,000.
But the learned judge proceeded on 41,663.
Yes, correctly. 41, my lord, 41,463 after deduction of the last item of 200
yes,
professional tax. My learned friend today says no. Whatever was gross, give me that. And from the gross, whatever was deducted, add again into the gross. So he says, give me 53 or 52. How can that be? My lord, I was getting a salary of 100 rupees. From my 100 rupees, 10 rupees was deducted as PF. At home, I was taking 90 rupees. But in actual, my earning was 100 rupees. The argument today is placed before your lordship.
10.
Yeah. I'm extremely grateful to your lordship. My lord, I need not go any further into this.
So anyway,
he is asking 100 plus 10.
So anyway, you have concluded your part.
My lord,
So
one last part. My lord, he is saying that for the daughter, filial compensation should also be granted. My lord, in this case,
the wife has got filial concern. No,
wife has got consortiums. My lord, the daughter is asking for more. My lord, cannot be done in view of planacity. My lord, I conclude my argument here. My lord, these are the points. But I hope I have been able to convince your lordship. Okay. My lord, take it up tomorrow morning so that my lordship doesn't forget this.
Okay, day after tomorrow. Day after tomorrow is a Friday.
Monday to Bondo.
Monday Bondo.
My lord, this will again, my lord, go out of mind. So the argument what had been recorded by your lordship.
Record and order. Learned advocates for the parties are present. Mr. Singh, learned advocate for the appellant, submits but could not conclude. Submits, has concluded his submissions. Granted to learned advocate for respondent number 1 and 2. 1 and 2 to submit on 13/1/2000
at 10:30.
26 at 10:30. Let this matter appear at 10:30 as a parted matter.
Extremely grateful to your lordship. I am obliged to my lord.
Lordship, kindly pardon me, Lordship. The 46-47, Lordship, is a passover on my request.
Yes.
Lordship, Mrs. Shatra has left the court, just to inform.
Yes.
Tomorrow 2 p.m. Lordship, because the first up is busy. Can tomorrow 2
No, let it remain in the list, okay?
Kindly, otherwise, because they are enjoying the stay order. Let
it remain in the list. Let it remain in the list. Thereafter,
submission, they are enjoying the stay order. The issue.
No, which year appeal? Appeal of which year?
Appeal of 2024, but it's a case is Lordship 2012.
No, appeal of which year?
Appeal of 2004.
Appeal of 2024.
2024, Lordship. But Lordship, the case instituted before the tribunal, and Lordship kindly see that it's 2012.
Okay, let it remain in the list. The matters are being taken up. Okay.
Case, Lordship, kindly
almost.
If possible, if not possible, no, I will not place, Lordship. My humble request.
Okay, you just wait for this week. On the next week, I shall fix matters.
Lordship.
কালকে থাকছে না, পরশু দিন থাকছে এটা নিয়ে
বললো